Extension of interim order, please hand over the slip.
Mala only for correct.
Yes.
Malon, may I permit to mention for correction of your lordship order?
Correction, please hand over the slip.
Lordship, am I allowed
Objection,
to?
please wait. Please wait.
I did Lordship, can I make an?
Please wait because I've fixed some dates. Please wait for the time being.
My lord,
Please let me see. Yes, I am coming from restoration application. Please hand over the slip.
coming from nursing home. May I file it? Application for
Applications, please hand over the slip.
restoration.
Any applications, please hand over the slip.
I'm coming from nursing home. It's a very short point. And lordship
Application, please don't mention.
no petition. My lord, today's matter, mention number 4 like this. Mention item number 4.
Mention item number 4. Yes, to be mentioned. To be mentioned.
Not to be mentioned. There is no caveat. There is a caveat. I am trembling like anything. It is
What do you want?
It is not that I am speaking.
Please hand over the slip. Please hand over the slip.
My lord,
Yes.
Your lord,
May I mention one matter for inclusion is to be mentioned, my lord.
Why to be mentioned?
It will be withdrawn, my lord. It will be withdrawn.
Withdrawn, yes, for release.
my lord,
Non-prosecution order to be mentioned.
I'm-
Extension, please hand over the slip.
your lordship, your lordship, may I permitted to item number 70 of your lordship daily list. There's a next date was fixed for the trial court before the tomorrow, your lordship. The interim order was the closed by the opposite party witness evidence, your lordship. Is the before the tomorrow's matter will not be heard, the London trial court will proceed with the hearing of the means suit, your lordship. Your lordship, on 7th July, this CO has been taken out, item number 70, on the prayer of the caveator who filed a caveat opposite party. The adjournment was given, and after 2 weeks, matter will
What
be
is the date fixed in the trial court?
It's your lordship tomorrow. Yesterday, I mentioned your lordship item number 70.
70. Who is
70.
sitting for the other side?
I already served the mention notice.
Hearing, sir, please
Mr. Sanjeev said.
inform him. Come at 2 p.m.
Much
Item number 70.
Much of
mentioning one matter for inclusion, my lord. My lord,
Sir, under what heading?
for admission, my lord. For admission. For admission, my lord. My lord,
Motion or contested application?
no, my lord, it's not under motion, my lord. It's a new matter, my lord.
When have you filed? When have you filed?
My lord, I can't remember right now.
Please,
My lord, actually, urgency is that, my lord, titles were.
inquire new motions. If you have given the date, it will appear on that date.
To mention, my lord, Landed City Court was pleased to pass the additional order, my lord.
What do you want?
My lord, the 915, the upgradation.
Upgradation, please.
My
Don't
lord,
mention.
construction petitioner. was
Maybe,
responded.
please. It's not possible because I have fixed some matters. Please wait for some time.
Inclusion in the list, my lord.
This application for certified copy. It's applied for the certified copy about a month back. It's not coming because of some difficulties there.
You have the server copy.
Copy there, my lord.
Leave to file with the server copy.
Inclusion in the list, my lord. Motion.
Yes.
Inclusion in the list.
Motion. Motion hand over
It's
the
the new motion, my lord. I had filed in the month of June, my lord. There was a caveat. Was directed to serve. Thereafter, the matter has not come up, my lord. It's very urgent because the peremptory hearing is fixed today, my lord. Anyhow, we have filed adjournment petition.
matter has not appeared.
No, thereafter, the matter has not been.
Hand over the slip.
Kindly give some preference to this matter, my lord.
Please hand over the slip for extension of interim order. I have told you.
I have handed for inclusion under the
Motion. Hand over the slip.
my interim order is expiring on 30th. I've
Hand over the
handed
slip.
over.
Please hand over the slip. Yes.
Mentioning for inclusion.
Lordship not adjourned at the request of the petitioner, my lord. So visitation matter. I am, my lord, the father not getting the visitation in spite of the, my lord,
specific order of the court that every week I'll get the visitation.
Hand over the
My
slip.
lord, I'm appearing in the list, my lord, any time may be fixed, my lord. Expiring in 31st August.
Please hand over the slip. You did not mention. Please hand over the slip.
Mentioning for inclusion under the heading motions, my lord.
Hand over the slip.
Much of that.
Yes.
But I mentioned your notice, but this is a contested application on the.
Please don't mention for contested application.
May I indicate, but on the last occasion when it was heard, my lord, directed, it should be listed on the first week of the month of September. However, that is not reflected in the order, my lord. My lord has kept it in the monthlies of September. Kindly, when some in that given, my lord.
Contested application, please not now. Please come after vacation. Yes.
No, there is some urgency to have the matter has not been heard for quite
Yes.
a long time.
Yes, on the list.
Kindly, item 150. This is a custody
Item
application, my lord. List, my lord. This is 17 application is pending with the tribunal, my lord. In the meantime, my lord, bank was directed to serve, give a reply. That is not done after consecutively 3 days. In the meantime, bank is proceeding before the magistrate, my lord. I have come out an application with the tribunal.
What do you want?
Now, my lord, 3rd September is the date fixed, my lord. Tribunal one order, my lord, in respect of my application, this tribunal does not, my lord, understand the prayer made. No merit. No,
What do you want, sir?
September is the lord, kindly one fix in this list. This list, my lord.
Not possible.
Custody matter, my lord. This is a custody matter. Your lordship was pleased to fix, my lord. It's with respect to the mother's, my lord, going to be see the child, my lord. Well, I have been restrained, my lord. Serious, my lord, things has been happening, my lord, since long. Your lordship was pleased to fix it on 13th August. Well, it's not getting hard. Well, if your lordship kindly fix it a date, my lord. Well, already, well, only the problem is I am not getting access.
Allow you to proceed serially, then it can be.
May I come back, my lord, after my lord?
Not now, please, because I have fixed many matters. It's not possible.
My lord, commercial court, stay order granted by the commercial.
What do you want?
The upgradation of the.
Upgradation, sir, please don't mention today for upgradation.
Stay order will be vacated by the.
Nothing will happen.
My lord,
Just call.
Motion matter, my lord, challenging the order or taking amendment. Only difficulty is they have other side of
What do you want?
challenging the order of amendment, other side already filed amended petition, my lord.
It
is before the
it
trial.
is appearing in the list.
Oh, my lord. For the inclusion, my lord,
Inclusion, hand over the slip.
we have to trial court matters on 29th, my lord.
My lord, may I be permitted to mention a matter? A civil division was filed in December and it is still not appearing in the list, my lord. It was pending in the learned first civil judge senior division in Alipur. I filed for expeditious here.
Kindly to mention one application for inclusion, your lordship.
Hand over the slip. Inclusion, hand over the
My lord, may I be permitted to mention an extremely urgent matter. 2nd September is the next date fixed. At the stage of argument, the learned
You want upgradation?
petition, my lord. My lord, order 6 rule 17 allowed at the stage of
Upgradation
argument.
not possible, madam. Yes, now. Upgradation, Mr. Ghosh, it's not possible now because upgradation, Mr. Ghosh, if it is appearing in the list. Upgradation, Mr. Ghosh, it's not possible. I appreciate that, Mr. Ghosh, it's not possible. Upgradation, now only 1 month left. That is why I've indicated in the list. Because I have allowed upgradation and I have also fixed, last 2 Wednesdays, I have fixed dates. It's till the end of September. So even if I accept, I cannot fix it prior to the vacation. That is why I'm requesting. I appreciate that, Mr. Ghosh. Please wait for a month. Please wait for a month because it's not possible. Even if I accept, it's not possible. That is why I'm not accepting.
Lord, my lord,
Yes. ওটা দেখে নিন।
my lord, may I be permitted to mention, my lord, upgradation for expeditious disposal.
No upgradation, madam.
Number 689 is against the Asansol Municipal Corporation.
Yes.
Not for water connection.
Yes.
But, Mr. Bhattacharya is appearing for
Item number 680
689 Milord,
of the monthly list.
of the month list.
So Bhattacharya is appearing.
But, he is the person who used to appear. Milord,
Please
for this.
inquire whether he is appearing or not.
No one is apart from him. Milord, no one is there.
689 of the monthly list. 689 একটা order করে দিন তো, since I'm not inclined
Lordship, I'm also praying for Arbitration.
Lordship, only one matter. Is the matter the item number one? Item number one.
What do you want?
Day after tomorrow, my right to.
Sir, you have heard I have not allowed any upgradation. Yes. Yes, who is in item number one? এটা কি? আরে, এই তোমায় বলি কি না? হ্যাঁ, কস্টাটল অফ দি অনারেবল কোর্টস অর্ডার ডাজ এরকম আমার নাম নেই, কস্টাটলটা ট্যালি করছে না। Next, the aforesaid errors be rectified. This order shall form part of the order. Yes, next. Lena. Oh. So why can sir? Can গুলো pending দেখাচ্ছে কেন? 5 of 2024 টা?
You know, the original can was not available on the date when the matter was moved. So we have given a copy.
Yes, but
was pleased to direct.
no, but the can why it is shown to be pending? না can তো dismiss বলে দেওয়া রয়েছে, pending দেখাচ্ছেন কেন? অর্ডারে তো dismiss বলে দেওয়া আছে।
Yes, my lord.
Can 5 of 2025 তো এই তো অর্ডার, হ্যাঁ? দেখে নিন, আসুন। It has further been pointed out that না yes,
Appealing for the petitioner, my lord, and on the last occasion, my lord, Mr. Anindya Chatterjee has made his substantial arguments, my lord, regarding, my lord, and after that, my lord,
It was sent mediation, what happened?
mediation, my lord, it has failed, my lord. As per my instruction, it has failed, my lord.
All right.
I am praying for a short passover, my lord, Mr. Chatterjee is arguing is to court number 29.
Mr. Chatterjee is in courtroom number?
Yes, come.
My lord, can it be fixed on some other date?
Yes, Mr. Chatterjee, what happened?
Application didn't work out.
Failed
Yes, ma'am.
because of you.
No, no, not at all. Because of a lot more things than what which I even comprehended was there in this matter. So any day, my lord, your lordship pleases.
It was at what stage? Motion.
Motion.
What is the extreme urgency, Mr. Chatterjee? Fixing it after the vacation. Is there any urgency?
Well, we had to file our written statement. Bobby?
File your written statement. What is the problem?
We say that, Milord, if we file a written statement, Milord, then things will go, Milord, in a different way.
What is the order in?
5 and 8. 5 and 8 arbitration. So if we
So
file
those
that
were the
written
interim
statement,
order passed. Any interim order has been
it was
passed?
understood that because it's gone to mediation, so the parties will not take any action. Keeps it after the vacation, Milord. In the meantime, let nothing be done in the suit.
Where is Mr. Chaturvedi?
My lord, he's in another court busy, my lord.
Then he
Is
said
it
at
another-
2, Milord, I'll come back at 2. 2 is very difficult. 1 o'clock.
Why?
2, Milord, appeal fixed before Justice Sen, and Milord, the other one is, Milord, before
The
the
advocates, senior advocates are likely to be engaged in matters.
it's just I'm a victim of circumstances.
That's the problem.
I am the most not busy advocate in the High Court.
All right, ask Mr. Chaturvedi to come at 1:15. Between 1:15 to 1:30.
Lord, can another day be fixed for the hearing? Can another?
এই জজ সাহেব চাইছেন কিন্তু আমি স্টে চাইছি সেই জন্য দাদাকে ডাকছি
Yes, Mr. Chaturvedi.
এটা এসে
Why did not cooperate with the mediator?
My lord,
Well, I knew that if I am not present, that would be the narrative given to my lords.
Chatterjee
Why-
has not given any
why does
narrative.
Mr. Chaturvedi always think that I'll say the negative or the truth?
Yes.
Lord, I do not have any instructions, Lord, on why the mediation failed. Kindly permit me to speak to,
Only that we can.
but now it has to be heard.
Now it has to be heard. So I think both of you have raised an interesting question. Can it be taken up after the vacation?
আমার অসুবিধা
Lord, could I come back with some instructions tomorrow?
Or what?
Lord,
Instructions on what?
Lord, because Lord, this
There is also a chance of settlement now. If
No.
you say so,
no, the question is not that. The question is, since after Lord, I was before my Lord on the last occasion, Lord, this has absolutely gone off my mind.
no.
And
That-
my learned advocate on record, he suffered a bereavement in the
No,
family. So
Mr.
he
Chatur-
gave
no,
me
I was
first
only
of all
asking you, I was only asking both of you,
My
not
lord.
only you, if this matter can be posted after the vacation, because both of you, if I faintly recollect, raised an interesting point of law, request to be heard. This side of the vacation may not be possible. That is why. Or if you want, it has to be sometimes after 4:30 of any day.
আমি 4:30 পরে দাদা আমার মাথা চলে না
Otherwise, the motions will get stuck, Mr. Chaturvedi. Nothing with regard.
No, on the
Anything
question of interim order, if my lord hears it for half an hour's time, any day,
that
because
your lordship has heard at
No.
length.
half an hour's time, any day, because my lord, I understand that if it is after vacations, my learned friend would insist for an interim order.
Yes,
Not an
because
interim order,
if you, no, what is the next date fixed?
10th September.
10th September, if an adjournment is paid for, if it is kept after the vacation.
I have no problem. Sir.
Very good. This can be done.
So I will give him liberty to pay for an adjournment. You don't oppose.
My lord.
Uh, I will hope that you do not come and disturb.
I hope so too.
Yes, next.
Number 4.
Your Lordship,
In this matter, my lord, I am appealing for the petition.
Second.
This is order to rule 6, which is argued before your lordship, my lord. Judgment on admission.
Your Lordship, just short pass over, Your Lordship, as Mr. Devjit Mukherjee is on his legs in court room number 18.
Only,
I think Mr. Mukherjee has made his submission.
only the
Mr. Rai
judgment,
wanted
only
to
one judgment required
make
to be.
some decisions.
Only, if your lordship, this is 2025 SCC online Supreme Court page 751. If your lordship may kindly consider judgment paragraph 19,
This is for what proposition, Mr. Rai?
order 12 rule 6. Your lordship can turn to paragraph 19.
19.
19. I got it. Oh, they get a copy there.
Yes.
Why the amendment objects of the order 6 has been considered. Now, I can turn to paragraph 26, 27, and 28.
Yes. Paragraph 26, what I was proposing on the last.
Yes.
Claims of particular relief, reliefs against the defendant, and the defendant makes a plain admission.
And the defendant makes a plain admission.
Yes.
That is why. Now, I can turn to paragraph 35, 34 onwards.
Yes.
35 is where I am arguing in a sense
Or
or
otherwise.
The
Or otherwise.
paragraph 35. The wide enough to include all cases of admission made in the pleadings or deferred the pleadings. Under Rule 6, as originally enacted, it was held that the word or otherwise without the word in writing used in Rule 1 showed that a judgment could be given upon oral or verbal admission too. Also, the amendment of 1976, however, made the position clear, stating that the admission may be in pleadings or otherwise, and whether orally or in writing. Thus, after the amendment of Rule 6, the admission are not confined to Rule 1 or Rule 4 or Order 6, but are of general application. Such admission may be expressed or implied, constructive. That is the argument which I have. Maybe in writing or oral, or maybe before institution of the suit, after the suit is brought, or during the pendency of the proceedings. The division bench of the Delhi High Court, my lord, has been quoted. The portion, your lordship will find it, or without determination of any other question between the parties, and can make such order giving it. The use of expression otherwise in the aforesaid context came into interpreted by the High Court, considering the expression that the court interpreted the said word by stating it permits the court to pass judgment on the basis of the statement made by the parties, not only on the pleadings but also deferred the pleadings. This is either in any documents or even in the statement recorded in the court. If one of the parties' statement is recorded under alternate Rule 1 or 2, the court of civil procedure, the same is also statement which elucidated the matter in controversy. Any admission in such statement is relevant not only for purposes of finding out the real dispute between the parties, but also to ascertain whether or not any dispute or controversy exists between the parties. Admission of, if any, is made by a party in statement recorded would be conclusive against him, and the court can proceed to pass judgment on the basis of such admission made therein. Here, my lord.
Yes.
Rule 6 of Order 12 before amendment allowed judgment on admission only on an application by the party. The law commission, however, suggested that a judgment may be pronounced either on an application by the party or even suo motu. The rule authorized the court to enter judgment where the claim is admitted and to pass a degree upon such admitted claim. This can be done at any stage. Thus, a plaintiff may move for judgment for admission by the defendant in his written statement, any stage of the suit, although he has joined issue on the defense. Likewise, the defendant may apply for dismissal of the suit on the basis of the admission by the plaintiff in rejoinder. This could may in appropriate case give the judgment at an interlocutory stage the proceedings admission by a party, but if the case involves questions which cannot conveniently be disposed of at the motion stage, the court may not give judgment at this stage.
The sub-rule 4 is inserted by court of civil procedure, requires the court to draw up a degree. Since the object of sub-rule 1 is to enable the plaintiff to get judgment on admission, the defendant, to the extent of such admission, he must get the benefit thereof immediately without waiting for the determination of non-admitted claim. So if you logically consider paragraph 37,
37 of,
his judgment, my lord, 37,
yes,
or otherwise on any pleadings.
read with 39.
Yes, the rule authorizes the court to enter judgment where a claim is admitted to pass a degree on such admitted claim. This can be done at any stage. So today it is their pleadings, whether it can operate against them or not.
Mr. Rai, what is the effect of Order 8 Rule 5(1) proviso? And the interpretation of the expression may
Yes.
used in Order 12 Rule 6.
That precisely, my lord, that portion has been also dealt with by this judgment. What is the effect? Why the may was inserted in shall after the post amendment? That was also considered. That is why, my lord, even Lordship may kindly consider.
Yes, yes.
Paragraph 21.
Yes.
Objects and amendments.
Yes. Paragraph 28 clarifies that. Not mandatory, it is
Obligatory or preemptory. This is also clear from the use
Discretionary.
not may in this.
discretionary and permissive enabling, not mandatory.
Yes, this
So, read with Order 8 Rule 5(1) proviso. So, court has the discretion.
court has
So-
to say the what may incorporates the discretion of the court. It shows how the discretion should be exercised. If the provision is there, whether the court can ignore that provision. I have to satisfy your lordship that whether this admission is admission for the
Even if there is admission, court can require that admission to be proved. That's the court's power.
yes. That if the court wants, I could have. If the court wants, that power is there. Every fact is required to prove, even if an expertise proceedings is there. If so factor does not
No, ex parte is a different thing altogether. Ex parte also you have to prove. Here is the question of admission. Even
Yes.
if there is admission, merely because admission is also an evidence. So even if there is an admission, even then the court can require, because there's a saying that the admitted facts did not be proved. So that does not require to be proved. Even then, Order 8 Rule 5(1) proviso says,
is the court.
court, yes, court,
Court
even if there is even if there is an admission,
then the
that
court
is
can.
required to be proved.
Court can. That is why. What is the order input? Whether the statement made in paragraph 5 mentioned in the plaint and the paragraph 9, whether it constitutes that he is a tenant, received the notice, and fixed charges is rupees more than 10,000. Then, my lord, if you logically consider the earlier judgment which I handed over to your lordship, the same term judgment, two things: the earlier justice decision bench of this honorable court. What are the requirements? Is jural relationship,
Transfer of Property Act, eviction.
eviction. So even if today, if you logically consider whether this required any, whether it can be termed to be an admission on the concept or otherwise, as mentioned in paragraph 37. It is a case made out by him.
Admission of what?
Status.
Admission of a
This letter.
claim. Admission of a claim made in the plaint.
Yes.
That's
Status.
the real test.
Yes. That
Not
is,
admission of anything else. It's an admission of a claim made in a plaint.
if,
So we have to test that.
on the basis of the prayer made and the cause of action. So therefore, one, if you logically consider what is the prayer made,
Yes, page.
page 57, page 56. Other plate.
Yes.
So his right to occupy the property. He is claiming declaration regarding his right to occupy the property.
That is in his suit.
In his
No,
suit. My suit.
39.
Can you turn to page 39? Extra right. Actor. E 39 কি হলো?
No, 39.
No, my lord.
The written statement.
34, 34.
Mr. Mukherjee is prompting you, Mr. Rai.
No.
Yes.
না না বললাম তো আমি
Eviction and damages. Eviction, recovery of possession.
by treating this to a suit under the Transfer Property Act. By treating them as a tenant, licensee, license, what is followed from a lordship, on the basis of which today also I am arguing the same thing, my lord. Defendant from the suit property is not entitled to get protection under the rent control legislation. In view of the statement made therein, whether this plaint averment can be considered comes within the purview or not. That is the only thing my lord has to consider. If your lordship can kindly consider turn to
Where is the eviction? Where is the notice that is annexed at page 27?
page 27.
So this was part of the plaint.
Yes, yes, yes.
27.
Yes.
This was part of the plaint.
And their reply also, because they are admitted in their, they have admitted.
That they have received this notice. And you have also admitted you have served this notice.
It is. As served, they have received.
And your suit is on the basis of this.
Transfer it.
106, this is to be considered to be a notice under section 106. And they are liable to be evicted. That's the
Main class of the, and one thing, my lord, it is
this notice also should be treated to be a notice under section 106.
106. I have correctly stated that it is a notice of the for eviction. I did not mention, but this the framing of the suit will depend on the, whether the notice is issued under what provision. I have expressed my intention to evict him within 15 days' time has been granted for evicting.
So this notice is to be interpreted by this court.
Nothing. Only the intention. Whether this notice unequivocally express my intention to evict or not.
Yes. So whether it's a notice under section 106 or not, that is also to be
No, no.
interpreted.
Page 28.
Yes, yes. Page 28, 27 starts.
Under my client has authorized and instructed me to write.
I'm saying that this is to be interpreted for the purpose of.
Interpreted, every pleading is got to be interpreted in that sense. So notice, my lord, if there is anything jumbled in the notice or not, I've categorically said vacate and deliver peaceful vacant possession of an occupied portion with the expiry of the month of June 2016, following which my client will file a suit for eviction and record your possession and damages. So this
Last time he argued that the duration কথা বলে
Yes.
time দিয়েছে
So this is the, so my equivocal communication to the other side that you have, I intended to evict you with a period of, if you fail to deliver possession with a period of 1 month.
Anything more?
And so far, my lord, page 49,
What is 49?
the admission regarding the fixed charges.
Yes, yes, that you have said, and you have also shown the document wherein monthly is,
Is their document. They have relied upon.
yes.
And my lord, I need not to, but for the sake of which general service?
What?
The composite rate, not variable factor. Can you turn to paragraph?
Paragraph?
Nine. Emphasis supplied after the 10. The propositional law enunciated in the aforesaid report.
Of 10.
Yes, the Gujarat Recreation Society has been considered. And after that, the proposition of law enunciated in the aforesaid report exposes the property tax cannot instruct a council in the purview of rent, but depends upon the intentions of the conduct of the parties. It can be said there is no uniform principle that property tax purview of the rent, but it depends upon the facts in each case. Consider from the example quoted in the aforesaid passage. It has been held that if the parties agree that the amount shall be in
This, Mr. Rai, is with regard to municipal tax.
tax. After that, my lord, if you logically
So where is the electricity? There is a decision on electricity.
yes, yes.
Here also it's electricity is there? No. It's only on municipal tax. Where is the decision?
Electricity is the fixed component.
Yes, yes, where is that? This does not deal with that. Here we are not concerned with the municipal tax.
Hmm.
Electricity, there is a decision on electricity.
They are fixed charges. Paragraph 6, if you lordship.
Deals with electricity.
Condemning properties. Well, may I read out?
Yes.
The earliest judgment of Supreme Court regarded was in respect to condemning properties.
Yes, yes.
Apex Court
Any
considered the issue
non-variable component
in non-variable
for
component.
use and yes, electricity charge.
Charges can be brought within the circumstances of rent. It has been held that any component which is variable in nature cannot be regarded as, but the component which is fixed shall definitely come within the definition of rent. And here, my lord, can you consider paragraph 4, paragraph 9, page 49.
Yes.
That apart from monthly rental of rupees such and such, the plaintiffs also payable maintenance charges rupees 5,000 and utility charges of about rupees 10,000 per month.
But this decision really considers that municipal tax and commercial.
Yes, but the ratio which has been considered because
Yes, it has considered
only
that
the service charge. This is there also the service charge here. There is the municipal tax. Here is the service charge. Fixed component.
Anything more?
These are my submissions.
Yes, Mr. Mukherjee.
He may be a very good case at the time of final hearing at the ultimate stage. Namarad, kindly consider that
I could not follow you.
he may win at the time of ultimately when the suit is decided upon taking the evidence. But kindly consider the scope of order.
Admitted facts, Mr. Mukherjee, need not be proved.
If I show from my pleadings, my written statement, other thing, your lordship has already seen the judgment. I think 2022 volume 10, the judgment delivered by Justice Maheshwari sitting with Justice Banerjee. It has been. But here it has been specifically stated that there is also a dispute regarding they are saying my expiry of lease, and I am saying that the tenancy. Now court says if you are to see the judgment on the basis of the admission made by the tenant in landlord suit for
Which
eviction.
paragraph?
But paragraph I will read what if you are to consider from paragraph 34, 37 and I will
34 to 37.
before that kindly similar paragraph 26.
26.
23.
Yes.
There must be a categorical admission.
Please give me a minute. Yes.
Kindly see. Order 12 rule 6 confer discretionary power to a court who may at any stage of the suit or suits on the application of any party or in its own motion without waiting for determination of any other question between the parties make such order or give such judgment as it thinks fit and proper. Thus, legislative intent is clear by using the word may and as it may think fit to the nature of admission. The said power is discretionary, which should be only exercised when specific, clear, and categorical admission of facts and documents are on record. Otherwise, the court can refuse to invoke the power of Order 12 Rule 6. The said provision has been brought with intent that if admission of fact read it by one side is admitted by other, and the court is satisfied to the nature of admission, then the parties are not compelled or full-fledged trial, and the judgment and order can be directed without taking any evidence. Therefore, to save the time and money of the court and the respective parties, the said provision has been brought in the statute. As per the above discussion, it is clear that to pass a judgment on admission, the court, if thinks fit, may pass an order at any stage of the suit. In case of judgment not pronounced by the court, a decree be drawn accordingly, and the parties to the case is not required to go for trial. Some special provision have been made in Rules 7, 8, and 9 regarding the affidavit of signature, notice, and procedure of document, and also the cost, which may not have been relevant for the facts and present case, hence not being discussed elaborately in the judgment. But here, what I am saying, where is the categorical admission? If I show the kindly see paragraph 26 also, this has been considered, the three judges bench also, there is says that he may a good case ultimately in the trial. But when I filed a suit initially for decree of declaration that I am a tenant, he entered appearance, he filed written statement, that suit is contesting, suit has matured for hearing. Subsequently, during pendency of that suit, he issued a notice. He issued a notice, knowing fully well earlier suit is pending. In that suit,
No, your suit is the earlier one.
My suit.
Suit was for declaration of tenancy.
Yes. My suit was declaration of tenancy. He entered appearance, filed written statement, not take up plea that I am a trespasser. No counterclaim. When the suit has been he entered appearance. When the suit preliminary issue has been framed, he sent a notice. Issue has been framed. Sorry, issue has been framed. Then what happened? He sent a notice. In the reply, I said I have already filed a suit, and I never admitted that I am a lessee. Rather, my claim is that I am a tenant. If you like to see the reply. Now thereafter he filed a suit. Then his application.
They filed a suit for eviction of a licensee.
Therefore, my status, whether licensee or whether I'm a tenant, that has to be decided on by taking evidence. But mere I made a one paragraph, two paragraph does not mean it is not the intention of the legislature to cut off the matters that a suit for eviction. One, had it been the case that I filed a suit for declaration of a tenancy right, he filed a suit for eviction on the ground of tenant, it could be understood my submission. But when the nature of the right in the property.
No, Mr. Mukherjee, there is no registered list deed.
But there is no
registered list deed. So your claim is that of a tenancy. And the rent is from your own admission is more than 10,000.
No, kindly see once more at that paragraph. Only particular a page which has been annexed in the application. Kindly consider Order 12 Rule 6 application. And before that, if I say
Order 12 Rule 6 application may not be that relevant because if the admissions are there in the pleadings, because if there are two things, you claim to be a tenant. So let us assume for the present, yes, you are a tenant. And the rate of rent from the documents is more than 10,000. So you are not entitled to any protection under the rent control legislation.
But kindly see once.
But
You are
that-
not protected under the rent control legislation.
but
Mr. Mukherjee, you
That-
can be evicted by issuing a notice under section 106.
106, I have in my written statement, I have not categorically admitted to receive the notice. If
You have
I,
admitted.
no, kindly see my written statement.
Yes.
My written
You have not
statement
admitted.
categorically not admit. Kindly see once contents denied. Now,
Page.
kindly see my written statement.
Paragraph 13.
Yes, I'm coming, my page double না।
paragraph 39.
না, page double, ওটা তো তুই বললি।
39.
But kindly see, said categorically denied.
Paragraph.
13, page 39.
Yes.
That with reference to the statement made in paragraph 4 of the said plaint, it is categorically denied that the defendant did not pay any license fee from the month of such and such is found due as alleged. The lawyer nor a stent served upon the defendant is valid, but denied. But kindly,
This is
my lower court drafting lawyer, if you call your
ordered the lawyer's notice as sent and served.
kindly see,
So
denied.
sent and served, that is the admission. But you say
But
that they have said it's valid, you have denied that.
But conjointly has to read from the first paragraph in respect to paragraph 4. Whatever has been stated in paragraph, entire thing I have denied. If you are to take the first part and not the second part, but kindly consider with reference to the statement in the lower court, your lordship may have explained, but something has been drafted.
Lower court drafting, what are you saying, Mr. Mukherjee?
In lower court drafting, kindly visualize.
I'm not admitting you that submission.
But,
Don't say that, Mr.
but
Mukherjee.
something, just like me, he has drafted.
That's
Just
a
like me,
different
English
thing.
is not very good.
Don't say that lower court drafting because of this is.
No, lower court I should not
I be-
because now, my lord, kindly visualize, this may be drafted by like me, my lord. The English is not very good. But kindly see that with reference to the statement in paragraph 4 of the said plaint, therefore, paragraph 4 of the plaint, entire thing categorically denied. Now, that has to be proved. Where is the specific, if I put this question to myself, where is the specific admission in the, apart the document, kindly delete the document, don't go into the document. Where is the
Which document?
He is relying on document, the rent document, the khata, which are produced.
That is your document.
That has
If you have filed a document in support of your case, has to be relied upon. Why?
where is the, where is the categorical admission, admitting the case of Mr. Rai? And my kindly visualize now, today suppose in other way, if you think that my suit has been filed, for declaration of tenancy. Your lordship, my lord, in other way, he choose not to file a counter claim. Later on, my lord, he choose that I have to evict it only to issue a notice 106. But TP Act only notice has to be proved. My lord, when I have stated this paragraph 13, that the statement in paragraph 4 denied, therefore the statement has to be read as whole, not my lord particular word. Now I will prove that stage has not come. That the court has held that without evidence this cannot be decided. What the trial court has done? Trial court said that this is your statement, this is your written statement, and this is my pen and written statement. Considering both this, there is no specific admission, and without considering the status of the party, and without taking the evidence, this cannot be decided. Number, if you're at this stage, when referendship consider, number the court, while if I permitted to say, while lordship taking the burden, if the court is saying without evidence, I can't decide the same.
No, I'm taking the
While lordship taking the burden of the lower court, because the court has said without
only because of both of you. You are making these submissions.
I say, without evidence cannot be decided. And the judgment of Justice Maheshwari sitting with Justice Banerjee must, it has been specifically mentioned. And my lord, he should cite. He has also cited possibly the judgment of Justice Partition. Although my lord, in that judgment, it has also been subsequently discussed where the specific admission, the intention of the legislature, everything has been discussed. If you have considered, possibly Mr. Rai has cited. But kindly consider one.
Yes.
From paragraph 33, 34, onwards, and 36. But there must be a clear and ambiguous admission. He may be a good case. Your lordship can direct the suit be decided within 1 month. But
1 month.
But kindly visualize one thing. Now, where is the case made out on judgment or admission? If I put this question to myself, But although my lord, in this judgment, there is a categorical admission, but the Honorable Apex Court, my lord, has discussed everything and consider all the judgment.
That I have to consider whether there is a categorical admission or
Your
not.
lordship, my lord, your lordship is the temple of justice, my lord. Your lordship will decide everything, my lord. আবার কি রিপ্লাই দিবি রিপ্লাই পর রিপ্লাই হয় নাকি যা খুশি তাই করবি
Only one thing, page 29 is the reply which I have said in my plaint.
Page,
29,
what is 29?
the reply to my notice.
Oh, he has given reply.
Yes, that has been mentioned in the plaint itself. Paragraph 4. Because I have already indicated in the statement made, served, and
Mr. Mukherjee, you have replied to this.
that is why.
রিপ্লাই kindly see the
So,
answer.
that is a
Status.
different thing. So, service of notice not disputed.
Status.
That is a different thing. Service of notice not disputed.
But service of
Service of notice not disputed.
but kindly see the plain.
Because this is
But
reply to the notice of
Notice of
25th of May.
see the reply. Kindly see his plain. Amendment in the plain.
Paragraph 4.
তুই বল আমি তাহলে বুঝলাম আরবার রিপ্লাই দে তুই চেষ্টা বল তো কত
Yes, you have disputed that there is no landlord licensee relationship.
without every letter I leave it to your lordship whatever your lordship will decide. He may be a good case I'm telling. He may be a good case but without taking the evidence whether this can be allowed because there is no categorical admission in the plaint neither in the plaint neither in the written statement. What he is praying I leave it to you. What your lordship will decide temple of justice by here.
Uh,
Worship, this is my application for extension of the interim order.
Yes, who is opposing you?
On earlier two occasions also they did not appear.
They did not appear.
They did not appear. On earlier, this is the can 3.
No, have you served Mr. Mishra, Gautam Mishra, Mr.
Yes, yes. On earlier occasions also served to and yes, affidavit of service.
Have you given notice that it will be appearing today for extension?
That was not right. That was not right.
What to have given?
It make a
What to have given a notice?
my lord, extension was, my lord.
That is a different thing, sir.
In
They
the
have appeared, so you ought to have given a notice that he will be mentioning.
short time extension can be made
Please,
thereafter.
no, not today, please serve notice. Please serve notice
Then
upon
fix
them.
another date, my lord, I will indicate it.
Tomorrow it will appear, only not today.
So within tomorrow, I will, how I will
Yes,
serve.
please serve, yes. Next,
My lord, hand to
Number
hand
six.
service, my lord.
yes, yes, yes. Who is appearing in the next one?
The extension of interim order this is a assigned matter
Assigned matter.
তুই প্রথম বাস থেকে কেটে এসেছিল মিস্টার মিত্র আর্গুড দ্য ম্যাটার নো দিস ইজ
Assigned matter.
কে রিলিজ করলো বলতো
Oh,
অ্যাসাইন কেন হয়েছিল হ্যাঁ অ্যাসাইন দিস ইজ অ্যাসাইন ম্যাটার ও দেয়ার ইজ এ ডিসপিউট বিটুইন জাস্টিস মিত্র জাস্টিস দিস দ্য ম্যাটার জাস্টিস বাসু চৌধুরী and Justice Mitra, there is Justice Basu released one personal wrong. It is appearing in my lord.
yes, you are opposing. After hearing the
What is number 7?
Ramp for the petition.
1, 2, and 3. Yes.
Mirror matter was earlier extended time to 10 by different courts.
You are appearing for 4 and 5. What is the impugned order?
Impugned order, there is a, my lord, please see page 61.
Already, after hearing the learned advocates for the respective parties, the interim order is
Fine, my lord, now it is interim order on 2nd May, my lord was 50%, that is extended up to August.
can 2টা তাহলে কি হয়েছে?
2nd May,
না না, কিন্তু can 2 আছে তো। Can 2
extension.
can 2 is for that has been disposed of.
Last of,
Extended.
Partition number 8 वाला time for the petitioner.
Yes.
This decision is directed against an order by which my application for amendment of claim.
After hearing the learned advocates for the respective parties, the interim order is extended till the month of January 2026 or until further orders, whichever is earlier. It is appearing in the list.
It is appearing in the
Let the
formal.
matter retain its position in the list under the heading contested application. Call the next matter.
No, no, list is appearing.
It is retaining.
It is appearing in the.
Yes. Yes, Mr. Haldar.
Next matter, my lord, I am for the plaintiff landlord. This division is directed against an order.
Plaintiff?
Plaintiff landlord.
Yes.
Well, I filed a suit for eviction, teaching the.
Yes, who is appearing for the other side?
Mr. Saurabh Sen, my lord, is appearing for the
Uh,
opposite party.
Have you given notice?
Telephone, my lord, he asked me, my lord, that he is appearing, my lord.
Yes. What did he ask you?
My lord, if the interim order is extended, but I am suffering the, my lord, due to pendency of this
The interim order is extended, he does not have any objection.
objection. But division that, my lord, since 2020, my lord,
Hard-
last 5 years. Extension of interim. The mentioning notice was given.
After hearing the learned advocates extension by adjournment. After
Let it be fixed for hearing someday.
after hearing the
My lord, but
Yes.
your lordship, your lord, the matter, already extensive interim order. I filed a can application.
your file and can application.
And I upload that.
Have you notified have you served the can upon the other side?
This is the letter, I will submit and land and tomorrow appear. And yesterday, we have tomorrow at noon. Yesterday, we have this is the matter and but he signed the matter. He was present. Yesterday, he was present. And I will not.
The learned 12 weeks.
Order number 12.
Yes. Plan for the petition.
Yes. We, it can
Until on 11th of June 2025. Valid till the end of August.
yes. You are appealing for the opposite party.
I want to file the opposition.
What opposition? What is the impugned order?
Impugned order, by virtue of the impugned order, my application for amendment is being not rejected. So not
After hearing the learned advocates for the respect. What opposition?
I know the plaintiff petitioner suppressed some facts of the partitions to be earlier. Has been suppressed
Sir,
before.
by way of opposition,
By
sir,
filing.
by way of opposition, you cannot improve upon the case, then that was made before the learned trial judge. So what the documents were before the learned trial judge, come with that, I will take note of that. Was an application filed for extension?
It's within time.
What is Can 1?
Can one take issue?
Can 1 টা কি?
No blood. Can 5 ছিল?
What is Can 1?
আরো সেটা না। Can 1 আছে তো?
Next.
Item number 13.
And for the petitioner, your lordship, this is for extension of interim order, my lord. It is to expire by the end of August, your lordship. Order was passed on 5th May 2025.
Have you sought upon the opposite party?
Yes, your lordship, the petition was served. Affidavit of service is there, but it is returned with the note that addressee could not be located.
Then you have to serve again. The learned advocate appealing for the petitioner submits that the registered envelope addressed to the opposite party returned with the endorsement, the addressee cannot be located. First up, the petitioner is directed to serve a copy of this application upon the opposite party as well as upon the learned advocate representing the opposite party before the learned trial judge. First up, the interim order is extended. The interim order passed on 5th of
5th May 2025.
25 is extended till the end of the month of January 2026 or until further orders, whichever is earlier. Is it appearing in the list?
No, your lordship. It was not appearing in the list.
List the matter under the heading contested application in the monthly list after 12 weeks.
Grateful, lordship. Grateful, your lordship.
দাদার নামটা দিই।
Item number 14.
14 lordship, in this matter I am for the petitioner. Interim order will be expired lordship end of August lordship. End of August.
One.
I have the objection.
After hearing the learned advocates for the respect. Mr. Ghosh.
Opposite party number 1.
Opposite party number 1. You are opposing the prayer for extension.
I have the inspection report there. But pursuant to the order of our this court, the appeal.
the municipal had decided that issue, whether it is a construction or not. But thereafter, that order was passed by the municipality. That order was challenged by the that was
No, the municipal appeal has been dismissed.
yes.
Thereafter, they have filed the revision.
I know it.
So the revision is not maintainable. Why?
No, I am not saying that. I know. But that is a, the office order was, I have seen the order, which both have submitted. Without any inspection, that order was passed. The pro-sign board. Tomorrow I contacted my client also. Whether the inspection comes to, might be available to all support. It's a client also. So I have no objection, but let the matter be appeared in the month of November.
Is it appearing in the list? Mr. Bhattacharya, Lanet.
Sixteen loss. I am happy with the petitioner loss. The interim order till end of the August loss.
You are appearing for the opposite party.
Mr. Bihani, lordship.
What possible? Interim order I am extending after hearing the learned advocates for the respective parties.
My lord, I beg to appear for the opposite party number 2, my lord.
You are for the opposite party.
My lord, I'm
Is for the petitioner.
we have received the copy. My only prayer before your lordship, my lord, this is a suit of 2006. My lord has stayed the proceeding of the suit. I'm just praying if a time can be fixed so that a matter can be heard out, my lord. Since 2006, my lord, it is being, my lord, it is the suit is pending, my lord. That is my humble prayer.
The impugned order is refusal of the prayer to recall the
Commission.
So commissioner,
But my lord,
right to cross-examine the commissioner.
My lord, I'm just praying that my lord kindly fix up a date, my lord.
So what do you have to say? If you want, I can allow that his prayer.
Then kindly fix up a date. Let me come back, my lord. Let me
coming back.
I right now do not have the brief with me. Kindly keep it tomorrow. At least keep it tomorrow, my lord. For that.
No, not possible.
And then anything subject to my lord's convenience. Kindly extend the interim order. I'm not approving that.
After hearing the learned advocates for the respective.
Eighteen.
I
am happy with the petitioner lordship.
12 weeks.
Interim order till end of
the opposite party. They will suggest taken on record.
I'm opposing it. My eviction suit is being stayed. Very short matter. If the matter can be taken up for hearing.
Yes.
I'm for the opposite party number 1. Opposite party. My kindly takes up my claim. Admittedly, it is a suit for eviction under 106 of the TPI. 106 of the TPI.
So where is the scope of section 7172?
There is no scope. Admittedly, there is no scope. But the difficulty is two things. That is, I'm entitled to get the occupational charge.
That is a different thing altogether. But 7.3 could not have been invoked.
That is admitted, sir.
So I'm allowing this civil division application.
But two more things I'm asking for. That's one thing is that I'm entitled to get the occupational charge.
Occupational charge, if you are entitled to take steps, I'm not stopping you from that, but the written statement cannot be
Well, kindly hold that one and
what? No, nothing. This application under
for judgment from the coordinate bench is there for the
for what?
occupational charges during the pendency of the suit in the suit for eviction.
Hey, you want to put it?
It might not time to come to the internal page, page number 5.
Madam, have you seen the decision of the Honorable Supreme Court? Have you seen the decision? This issue has not yet been decided. This issue has not yet been decided whether in a pending suit, occupational charges can be directed to be paid. Not decided. Supreme Court in a special leave petition on 2 interlocutory applications being filed, directed deposit before the registry of the Honorable Supreme Court. So till now that issue, madam, I'm not on that. Till now that issue has not been decided. I'm not making.
They can deposit it before the court.
I'm not. You take steps before the learned trial judge. I'm not stopping you. I'm not making any observations on that.
Can it give a direction for expeditious disposal of the
Yes, that has to be given. That I will. But then your occupation charges and other things, that is for you to decide. This application, though this matter is appearing under the heading
My lord, there is no caveat, your lordship. No, my lord, I'll just indicate, my lord, this is my application. This is my application seeking expeditious disposal of a consumer complaint, my lord. That was filed in the year 2022, and my lord is pending before the Learned Tribunal Consumer Court at Rajarhat. Now, my lord will kindly appreciate if your lordship, I have already annexed the orders. Once on the ground, my lord, that unnecessary adjournments have been made, my lord, and that was allowed.
What is the next date fixed?
Next date it fixed at 28th January 2026
For
my lord, for
argument.
final arguments. No,
This application under Article 227 of the Constitution.
when 16 July 2025. Subsequently, your lordship, on the prayer of the opposite parties, the matter has been further delayed for 5 months, my lord. If, my lord, the petitioners are senior citizens, if it can be,
It will be taken upon that date.
my lord,
Yes,
disposed of
call the
in 2
next
months, my
matter.
lord, if it can be, my lord.
No further adjournment.
Yes, yes.
The 7172 application, it was filed within time, but my lord, it was deposit was made belated. Deposit was made belated. My lord, I am not the I am the plaintiff in this suit, my lord. Happily.
Yes.
What has happened under the watch of the court, this has been done. The extension, they filed the, my lord, the application on 7172 within the statutory period. But it was not served upon us. The court gave a date after 3 months. Because on that day we were served with the application 7172. The 71 was allowed, but that could not have been done. And my lord, at the time of
71, where is the scope of filing any application?
there is no scope. There is my lord's own judgment in Parvati Shodan Rokit, my lord, I'm armed with that as well. My lord, they have filed that application, but they did not tender it to me either or file it with the court. My lord, they have just filed the application. That application was allowed. Well, at the time of hearing of 7-2, my lord indicated this to the court. The court says, because my predecessor allowed it, you go and file a civil revision. This was the language, my lord. File a revision before the Honorable High Court and get an order. I will not dispose of the 7-2 application.
7-2?
This at the time of hearing of the 7-2, these documents were supplied to me. The 7-1 deposits. I've said these deposits are belated. Said the court. The court said I cannot do anything. You go to the upper forum. I will not pass an order on 7-2.
No, no. What is the order you are challenging?
But that is the last order, my lord.
Order dated?
Order date I'll indicate, my lord. There are 3 orders that I'm challenging. Order number 4, 5, and my lord, the syndicate. The order date is 16-6, order number 16.
Order number 16.
16. Kindly, I'll just show it from the beginning, my lord. Kindly have a look at the, my lord.
Give me a minute.
The 7-1 application ta kotha? The 7-1 application. Wait, no?
Where is the order passed under section 7(1)?
Milord said, order number 3 and 4, Milord, that's relevant. 3 first, Milord, kindly take us 3 first. Order number 3 dated 13th of February 13, 2023. They received the summons, this is admitted fact, Milord, received the summons on 20th of January.
They received the summons on
20th of January, page 38. My lord, will find it from page 38.
20th of January.
20th of January 2023, they received the summons.
Yes.
My lord, then 13th
So
of
they filed 7(1) within time.
filed the 7(1) within time. But deposits were not made. Not the rents were tendered to the landlord. Or any attempts made to get the applications heard out. They did not even serve us the copy.
Yes. Now, 5th of April, an order was passed.
5th of April, the application was allowed.
Yes.
We objected, that application was allowed.
5th of April, order was passed in your presence.
This was passed in my presence. Milord, then what happens? Milord, we
You have
don't
not
know.
challenged that order.
Milord, I say, Milord, why? Milord, this is the humble submission, Milord. But this is a bulletproof jacket which the tenant has to wear in order to get. Milord, I'll indicate, Milord. Milord, I am armed with the judgment of this court, Milord, of a coordinate bench, Milord, when says, Milord, even if a 7172 application is pending and the deposits are not made in time, still there is no scope, but 73 will be invoked. Well, this is a coordinate bench judgment of this court, Milord, my Lord Justice Champa Sarkar. In this, I appeared, Milord, and it was turned down. My 7172 application was pending. During pendency, 73 was invoked. And kindly looks at the first, second, or third paragraph, Milord. The facts are laid down. Mere filing would not do. Character judgment. Character copy name. Character refer code.
So show me that in 7(1) that has to be deposited even if the application is pending under which
This-
paragraph says so?
Milord, this is the facts, Milord. I will find
So
for the
which
facts.
paragraph says that even if the application is pending, you have
In
to
this
deposit?
case, Milord,
Show me the finding. Show me the finding.
I'll show, Milord. The
Whatever
revision
may be the fact, show me the finding.
Then advocate Peter submits that a 7(1) application was filed within time, but the same was pending before the learned court.
No, that is the fact. Show me the observation of the learned of the coordinate bench that even if it was pending, if deposit not made, gone. Show me that.
I'll take some time, Milord.
Yes.
For the elderly provision 7 was mandatory and the tenant in order to seek protection from delivery of possession in a suit. In order to tenant to seek protection from the delivery order of possession of in the suit for eviction under any ground under section 6 of the act would have to deposit the admitted area of rent along with 10% within 1 month from the receipt of the summons or within 1 month from the date of appearance if the tenants appeared without summons. But this is the settled position, Milord. With
No, show me that sir, if the court fixes a date after 1 month, where is the fault of the party? Show me that.
But this is what happened in this matter, Milord.
Sir, it's not the, that's not the
That is the facts
observation.
laid down, Milord.
Sir,
What
that's
has
not
happened?
the observation of the coordinate bench.
But this is the facts laid down, Milord. What has happened?
Facts have been laid down, but that's not
Even
the
a 7(1)
observation.
application is not contemplated.
Secondly, why shall I allow you to challenge an order of 2023 in 2025?
Because, Milord, there are some other grounds, Milord, which have come up at the time of hearing of 7(2).
Order of 2023, 2025, no, sir.
Milord, what has happened? Milord, I have indicated why there is a delay. Milord, at that when they have deposited, Milord, only at the time of hearing of the 7(2), while order number 16 was being passed, Milord, they are supplied with the copies of the deposit challans. Once I have a look at the deposit challenge, only then I can object. Well, 7(3) is automatic in nature.
Sir, when this order was passed, 5th of April, 2023.
But this is not, Milord, kindly appreciate, Milord, this is not my liability.
Please allow me to make my observations. 5th of April, 2023 order was passed in your presence. By this order, they were allowed to deposit. So you knew that this order allowed them to deposit beyond the statutory period, could not have been done. So if that was so, why did you not challenge at that relevant?
Now I say why, my lord. You will kindly have a look at order number 3 once. The order number 3 is the principal order which is defective. You will kindly have a look. The order number
But
3
you have not
says
challenged that.
why say, my lord,
That
order number, even if I challenge it out, my lord, on 5th of April, my lord, by that time 3 months have already passed from the date of service of the summons, would not render anything, my lord. Well, even after passing of the 2 months or 3 months I come, my lord, then also would not help them because 1 month period is already passed by that time. Well, they have filed it on 13th of February. My lord, when I for the first time I come to know of the application on April, my lord, they received the summons on January.
So what is the suit for? On what ground?
Eviction for the defaulter and, my lord, reasonable requirement.
So you do not have a good case on reasonable requirement.
That I do have.
So I'm
That I do
asking,
have.
If you want this point to be decided relying upon a quarter, I can refer this to a larger bench.
We'll refer this, my lord. We'll kindly.
Want that?
We'll let it be referred, my lord. At least we'll save it in either this way or that way.
No necessity to refer. I can pass a judgment on this. No necessity. I'm asking you. I was. You are interested in getting this point resolved.
Well, I'm really interested. Well,
You are a landlord. What are you
if
saying?
this happens, well, at least in that order, well, I could file a review.
The fault of a party when the court fixes it, court is not aware.
Well, I say why, my lord. I say why. Kindly, this is for academic discussion, my lord. Well, it is a bulletproof jacket, which the adversary has to wear.
Anything more?
They have to wear it, my lord.
Anything more? This order, yes. What is the other order?
My lord, the other order is my lord's own order, my lord. In Partition Rokit, paragraph number 32, I'll indicate.
Yes.
Select a copy name. It is a reported judgment. Well, this is my lord's order, my lord. Therefore, the tenant, I'll just find out. My lord, a deposit or payment of rent under clause A and clause C of section 7(1) of the WPT Act 1997 does not contemplate filing of any application. My lord, what I say, my lord, kindly have a look
on that.
There is no dispute. My lord, kindly have a look at section 7 once. Section 7, my lord, also knows, my lord, this. Well, I'll just read the relevant part. Pay to the landlord, that comes first, or deposit with the civil judge. Well,
after filing the suit, you would accept.
After filing the suit, that is possible.
I'm asking you.
There is judgment to that effect as well. Even if I accept,
are you ready and willing to accept?
Well, in a 7(2) on the basis of a 7(1) application, will yes, or if they say in terms of 7(1),
are you making the submission after taking instructions from your client, or you are making?
Anyways, they are depositing. Anyways, they are depositing, Miller.
That's a different thing. That's a different thing.
They could have at least tendered it to me. That was also not done.
Why they will tender?
Filed it. They could have filed it with the court. Well, this judgment also says that.
All right.
They have to file it with the court.
No, what is the challenge to the other orders?
Well, other orders, those are bad in law. The 3, 4.
No, order number 16, what does it say?
Order number 16 tells me go to the revision court, go to the upper forum, get the order set aside.
For challenging that order of 2023.
For challenging the order of 2023. Well, I was never challenging that order of 2023. I was just saying that when I received the challans at the time of hearing of 7(2), I see that there is a belated deposit.
Anything more?
Kindly let the court decide once.
What?
The court below under 7, the aspect of 7(2) has not been disposed of as of yet.
7(2) will be disposed of.
In accordance with law.
Everything has to be in accordance with law.
Judicial discipline comes with me.
Everything has to be.
Judicial
This application under Article 227 of the Constitution of India.
Grateful, my lord. Grateful.
Thank you. তো বললো যে বড়তে আছে হ্যাঁ তাহলে আফটার 12 weeks চল কোথায় গেল
That item number 909 of the continuous. She was supposed to operate that category.
909
Yes, not she was supposed to operate that.
yes it is appearing in the list
But the date is considered. The activity taken up by trial with the
that can
In this, the next month, 10th, accordingly, report has come. My lord, can you fix up tomorrow, otherwise it will be
Where it is appearing?
my lord,
It is appearing in the list.
not happening. Earlier occasion mentioned, the record has come before lawsuits in this court, record has come, and execution proceeding with this,
Record has come.
yes, ma'am.
They can.
My lord,
My lord,
petition number CO 3194 of 2025, which has been filed today, taking leave from your
No.
taking leave from your lordship without certified copy. My lord, similar set of matters have been listed in your list, my lord. It was released due to some difficulty of your lordship, my lord. My lord, similar set of matters are listed on Monday, my lord, so that the matters may be just to be mentioned so that we can use the same from your list, my lord. And
I know this. Yes, call the list.
Item number 70.
Your Lordship, in this matter, I am appearing on behalf of the petitioner. Your Lordship, by any impugn order dated 16 June 2025 at page 43, the learned court below has closed evidence of the DW2. DW1 is husband, his examination as chief and cross-examination has been completed. DW2 is the mother of the husband and his examination as chiefs and partly cross-examined. Thereafter, she fell ill, your lordship, thereafter she also hospitalized. On the medical grounds, we have sorted the adjournments. But ultimately, when 16 June 2025 on the medical grounds have sought the adjournment,
Yes. Is she now fit?
now it fit within 2 weeks if grant time, the examination, the cross-examination, the opposite party can be completed.
That is DW2.
DW2.
What is the next date fixed?
Is tomorrow, your lordship.
Tomorrow she can be present.
To us at present, she is in native place. I need 1 week time at least. And the next week, effective first week of September, she will be present.
Today, where she is now?
She is, your lordship, Uttar Pradesh. Exact location, your lordship, it's Mathura, Uttar Pradesh. Mathura.
Yes, what do you say?
argument already started. My lord, I want to hand over the entire order sheet before your lordship. My lord. If your lordship kindly see that. My lord, since January 2024, your lordship kindly see how the opposite party petitioner had, my lord, dragged the case. My lord, 24th of January 2024, evidence of PW was closed. My lord, not only that, my lord, earlier there was two directions for early disposal passed by this honorable court. My lord, thereafter, my lord, 24th January 2024, evidence of PW was closed. And on 23rd of February 2024, date was fixed for evidence of PW. My lord, 7th of June 2024, last term, 8th August 2024, cost was imposed. Not only that, I want to draw your kind attention, my lord. If your lordship kindly see the order number 103, dated 13th January 2025.
Yes.
What is, my lord?
Yes.
My lord, last paragraph. What it appears reasonably from the nature of the prayer of the adjournment is that the respondent is purposefully trying to linger the matter despite the order of the honorable court. Thus, as a whole, the prayer for adjournment as filed today by the respondent is rejected. In order to dispose the matter earliest as per the direction of the honorable court and to cause the balance of convenience, this court is of opinion that the above named witness should be directed to be examined by appointing a commission. Thus, the respondent is directed to file appropriate petition allowing the above witness as PW2 commission, and the said appropriate petition must be filed before this court at the earliest on 15th of January 2025, and on the said date this court will pass necessary orders appointing commission so that the above named witness be examined as DW2 by way of commission. My lord, if your lordship kindly see the next order. Order dated 15 January 2024. On that very next date, my lord, the witness as DW2 was appeared. No steps has been taken to take evidence on commission. Well, not only that, since long, my lord,
On the next day, DW2 was examined and cross-examined.
not only cross-examined.
15th of January,
Examined
and cross-examined.
And thereafter deferred. My lord, not only that, no single maintenance has been paid in spite of the specific order passed by the learned court below. Since 2023, my lord, not a single amount, my lord, has been paid to the wife. Each and every, since January 2024, my lord, each and every occasion, my lord, they file adjournment. And several times cost was imposed, last chance, special chance, my lord, your lordship, kindly observe that how the husband dragged this suit. Earlier, two directions for early disposal passed by this honorable court.
Upon instruction, I am to submit regarding your lordship, the maintenance. The maintenance has been granted, but they don't prefer any execution as they do not.
Why they will file an execution?
Your lordship,
What for?
your lordship, your lordship, may I submit?
My lord, that warrant of arrest has not been executed.
They will have to pay for execution, then he will pay.
No, your lordship, they did not they did not want to proceed with that maintenance as because I am the petitioner came for any information from reliable sources that the wife again she remarries and regarding
have you paid are you complying with the directions for maintenance?
No, your lordship.
Then
Since 2023, my lord, he has not paid a single amount, my lord. Petition is pending, warrant of arrest issued, but cannot be executed. Till August, my lord, according to me, my lord, 1,61,000 disputes.
Your lordship, give me first week September, 2 days fixed. I will complete the.
No. You have not paid alimony, sir. No, nothing.
Argument already started.
Yes.
Your lordship, there is a several allegations against father-in-law, mother-in-law. Father-in-law expired during this litigation, during the pendency of the litigation. The mother-in-law is alive. He has to counter these allegations there on the ground that the divorce they seeking, your lordship.
Yes. Where is your application for adjournment, which you filed on 23rd of June?
Your lordship, that has not been annexed, but I have the documents which I relied upon during the paying for the adjournment. This is a medical fitness certificate, issued by the concerned hospital, your lordship.
Quite a specific order, no steps has been taken to examine the DW2, my lord, on commission.
Ashu, this application under Article 227 of the Constitution
One.
None appears for the petitioner at the time. None appears for the petitioner at the time of call. No accommodation has been.
But I'm for the petitioner.
Yes.
The shoot for partition. Plaintiff is the petitioner before your lordship. Assailing an order whereby the plaintiff's application under Order 6 Rule 17 has been turned down. My lord, may kindly see the schedule of the amendment I have shot for at page 27. Only formal application, one-storied building, it will be three-storied building. Shoot for partition that has wrongly gone down, but the defendant in the written statement has accepted.
One story to three story is a
Yes.
formal.
My lord, may kindly see, my lord. Page 27.
At what stage?
But the
What
evidence of PW1 has commenced.
has completed?
Commenced.
PW1 commence means
Cross-examination, no, cross-examination has not been done.
cross-examination may not have been done.
My lord, may kindly see
Documents tendered it evidence.
so far.
Marked as exhibits.
My lord, that does not appear. My lord, only one thing has been recorded. If my lord may kindly turns to the ordering portion, page 2.
Further case of the defendant that during cross-examination of PW1.
No, defendant. No, during cross-examination it has been pointed out. But the defendant in the written statement has accepted.
So if it is during the process, it was pointed out thereafter amendment. So it has to be commencement of trial, Mr. Basu.
My lord, that is already formal in nature. My lord, that will not change the nature and character.
That's a different thing. I'm asking you whether the trial has commenced.
But trial, the
Whether formal or not, then I will consider.
My lord. My lord, may kindly consider, my lord, the one-storied building that has gone down in the plain schedule, that was erroneous. The defendant in the written statement has accepted that it is a three-storied building. Kindly comes to the written statement at page 20.
This only one property involved in the
One property. Kindly come to page 20, paragraph number 9. The defendant number 1 denies and disputes the statement made in paragraph number 12 of the plain. The defendant number 1 states that the premises 9/A Rajbihari Avenue, PS Kalighat, Kolkata such and such is a three-storied building. So it is the defendant's case that it is three-storied building, but erroneously in the.
Where is the written statement?
Written statement, my lord, it starts at page 19.
19, which paragraph says?
And page 20, kindly come to paragraph 9, page 20. First 3 lines.
First 2 lines.
First
The
3 lines.
Three-storied building.
Yes, three-storied building that the defendant has accepted in the written statement. But erroneously at the time of filing of the shoot, my lord,
Where is their application for amendment?
My lord, may kindly comes to page 25. Paragraph 2, I have stated that the petitioner, after scrutinizing the plain written statement evidence of PW1 and exhibited documents for preparing argument, it is found that some typographical and or clerical mistake was found at the plain, for which the shoot which has been rectified by way of amendment specifically described in the schedule of the instant application, and the same is absolutely necessary for proper adjudication of the dispute between the parties thereto in the instant shoot. That the said amendment is formal in nature and if allows will not change the nature and character of the present suit, nor the proposed amendment will prejudice to the defendants. That the proposed amendment is the plaintiff PW1 has admitted in the affidavit in chief that it is a three-storied building. I have also admitted in my affidavit in chief. I have also said that it is three-storied building. And there was another amendment which I am not pressing because it relates to the valuation. In the plaint, I have stated it is a 3 lakh valuation. But the learned trial court, my lord, dismissed it that it will change the nature and character and it will cause prejudice.
There is some
Ma'am, please, Your Lordship, my lord, petitioner before Lordship is the defendant in the suit for eviction, wherein he has come before this.
Yes.
My lord, what has happened, Your Lordship, an application.
You are the defendant.
Yes, Lordship.
Yes.
Order 9 application was allowed subject to payment of cost of rupees 26,000. Initially, there was no date was fixed, but subsequently, I was directed to submit that deposit the amount within 5 months.
5 months?
Yes, Your Lordship. My lord, I could not collect the amount, but at the time when I came up with the money and went to deposit, my lord, it was found that the
5 months expired on. 5 months expired on.
My lord, it will be evident from the order itself, Your Lordship, at page.
I'm asking you, 5 months expired on when?
It was on 2018.
2013,
2018.
18?
Yes, Lordship. My lord,
how many zeros you have to put after 26,000?
My lord, very
From
poor person, Your
2018.
Lordship.
How many zeros I am asking you? Choice
Lord,
is
it's a
left to you.
Small shop room, Your Lordship. My lord, anyhow I could collect the amount and went before the learned court, and it was
You have
found that
invested that amount. So how much? Double, triple, how much? Where did you invest this amount?
26,000, Your Lordship.
26,000, paltry amount of 26,000.
No,
So, yes, how many zeros after? On the right side, not on the left side of the figure. 1, 2. With that, I will allow you. Not on 26,000.
Make it 30,000.
No. 30,000, don't change anything on the left. Right, add anything. Any figure, 0 is the lowest amount. That is why I asked you, gave you liberty to include any number of zeros.
Adding zero, that would lead to lakhs, Your Lordship.
Yes, yes. That is why. 2018 it is expired. Today we are in 2025. Price index.
But it's not 18, Your Lordship. On 38, 2000, upon reason the record, the case has already been disposed of on contest on 38, 2024. Order was passed on 38, 24. Within 5 months, I was directed to pass. I was directed to deposit the amount, but I could not do so.
Then you have applied for extension.
No. Then I just, order was passed on 38, 2024. I was directed.
What is the order? Which order you are challenging?
My lord, I'm challenging the order, Your Lordship. Order dated 23/6/2025. Wherein my application was turned down. On an application of the opposite party, Your Lordship, an order was passed on 24/3 of 2025, wherein the opposite party has stated that.
So what happened after that?
My lord, I have come before this honorable court, Your Lordship.
In the suit.
The suit, Your Lordship, decree was set aside. I was directed to make the payment. I could
now
not do so.
execution possession has been taken.
No, not yet, Your Lordship. Not yet.
When the possession will be taken?
My lord, they will start the. This is at the initial stage, Your Lordship.
Ex parte decree was passed.
Yes, Lordship.
Set aside, subject to payment of cost.
Yes.
Not paid. What is the effect? Ex parte decree revives.
Yes,
it's only to be put into what remains. Nothing.
Yes, Lordship. My lord, that ex parte decree was passed. It was set aside on 24th of March.
What set aside? Because subject to payment of cost not paid, ex parte decree is to revive.
Yes, Lordship.
What are you saying?
My lord, yes, Lordship.
So it has not been set aside. That was subject to condition.
Yes.
Condition not satisfied. So now it's only the execution.
Yes, Lordship. But I want to say, Your Lordship, not kindly, Your Lordship.
What?
Kindly. My lord, order was passed on 24th of March 2025. I was directed to my application under order 9 was allowed. Subsequently, Your Lordship, I made an application. I moved before the learned court and filed an application for deposit of amount. And by order dated 23rd of April 2025, I was said that since 23rd of June 2025,
and that application was rejected. My application was rejected. Anyhow, after due hardship, your lordship, I had collected the amount I want to deposit.
26,000 is not sufficient.
Thank you, lordship. I leave up to your lordship. But adding zero, that would be very, he'll not be able to do it.
Double the figure. You may not add. Multiply it by 2 times or 3 times, subject to your choice, as you want.
It's a small shop room, my lordship.
Oh, shop room, you are earning much. That is why.
I'll take instruction, your lordship. Copy. Well, make it 40,000. Kindly.
40,000.
Yes. Okay.
The that amount which you have quoted,
yes, lordship.
because now live streaming is on,
Yes, lordship.
so recording is also being done.
Yes, lordship. Obliged,
So
lordship.
don't pay much time to pay that amount. Yes, call the next matter.
I am on caveat.
You are on caveat. You have been served.
Yes, my lord.
Yes.
My lord, I am appearing for the petitioner. This is a suit on the petitioner is the plaintiff of the suit. And he, in the evidence, the evidence of the plaintiff has been completed. And after that, my lord, the defendant disclosed some documents. And one of the documents is, my lord, Annexure B, page 19, my lord.
Yes.
Yes, my lord. The defendant disclosed some documents, and one of the documents is, my lord, Annexure B, page 19. They have discovered the document, but the witness has not been produced to examine this document. We have made an application before the learned court below for summoning of the witness.
Yes, this document was produced in evidence.
Yes, my lord.
Then what happened?
And we have made an application before the learned court below for producing, for summoning the witness of Annexure B, page 19, my lord.
Yes.
For examination and cross-examination.
So who has produced this document? They have produced this document.
Yes, my lord.
Has it been marked as an exhibit?
Yes, my lord.
In cross-examination.
In cross-examination of him.
Us. They called for this document in cross-examination.
No, yes, we
They called for or they tendered this document in cross-examination.
Cross-examination, they put me a question that whether you can produce the document issued by this Jonokol and Vidyantan. We said that yes. When we produced that, it was marked as exhibit in cross-examination.
It was marked as an exhibit.
Yes, my lord. Page 18, kindly see, my lord.
But the learned trial just says it is pertinent to that no document is found on record.
Yes, that is wrong, my lord.
I checked up the record, it was marked.
It was marked page 18, my lord, the cross-examination of TW1.
Where is your application?
My application is, my lord, in the letter exhibit annexure PC annexure D, my lord. We have made the application.
So, Mr. Chatterjee, this has to be remanded because it was.
Lord, there is no other reason.
Has to be no other reason.
My lord wants me not to say, my lord, why at all it should not be allowed. My lord, since the application has
The trial judge has not considered that.
I understand, but I was.
So I'm setting aside this application under Article.
Because I will only that the argument stage these applications are come. Court has fixed it for argument.
But not rejected on that ground, Mr. Chatterjee. Not rejected on that ground. I could have appreciated it was rejected on that ground. And moreover, when a document has been produced, so a witness, if he wants to call that witness, that can be summoned.
Milord, there is some principles attached to Milord, Order 16, Rule 1. Milord, those principles, if are not compliant, Milord, from evidence I will show. Milord, produce this document in cross-examination. Milord, after closure of defendant witness, Milord, he recalled his witness.
No.
Where, Milord, he said that I have substantiated my case.
All right, so.
So, Milord, the application, if my lord sees, is bereft of any reasoning which Milord.
But the learned trial judge did not consider that. This application under Article 227 of the Constitution.
First line is recorded, record is fixed for argument. So that line is recorded in the intro.
This application under Article 227 of the Constitution of India is at the instance of Kolkata Municipal Corporation is aggrieved. By whose order? Tribunal. Rarest of rare case.
Against the order
Rarest of rare case.
against the order of the order of the Municipal Assessment Tribunal.
Valuation.
Valuation often on the corporation comes to this court. But in this particular
But
case,
rarest of rare cases.
no, well, I have already in the last the 2-3 years or the 4 years, my lord, at least 80 to 100 cases I have done. And all cases the tribunal has passed in a mechanical manner order without giving any reason mostly. But in this particular case, my lord, against the review application, my lord, file review has been rejected by the learned tribunal.
Review filed by you.
Review filed by us, my lord.
So what happened? Assessing officer, hearing officer,
Assessing officer, my lord, fixed an amount of annual valuation.
At what rate?
But certain days that was not disputed about that regarding the amount.
Challenged or you they challenged?
They challenged in appeal.
Yes.
Appeal was a learned tribunal. Learned tribunal based on a particular document, the particular they produced. That was the attested by the notary public. Lease deed. But there is a particular clause. There is a judgment of the Supreme Court you also knows about that if the rent is inclusive of tax, then in the matter of calculation or the amount of fixation of the annual valuation, there shall be a reduction of 28% of the occupancy share. That is, my lord, judgment of the Supreme Court. And if that be so, if the rent is inclusive of tax, of course, my lord, the valuation will be reduced. Well, they produced the lease deed with that particular clause. The learned tribunal, my lord, passed an order accordingly. We took it bona fide that is the thing. And though when the execution process was done, whether to give the benefit or something like that, then we asked for a particular document from the assessee concerned. Then they give a registered lease deed to us. We find it's a different situation is their clause, particular clause. The amount to be reimbursed by the list. Whatever the tax to be paid, then it is to be already, then it cannot be an inclusive of tax. Then, my lord, we on the basis of that, my lord, the list deed, we file an appeal for review. That these were not correctly done. Then the learned tribunal wanted to compare with that the deed, my lord, which they produced learned tribunal the first instance, it could not be found out. It could not be found out on the record, and nobody could produce. They could not produce on the basis of that. The learned tribunal took into consideration that was the document. And learned tribunal at the end says that at this stage I cannot follow. I reject at this stage. I do not know. At this stage, I rejected the application for review.
Where is the order impugned?
Well, legal logical is not the last one. Page 136.
But Mr. Ghosh,
my lord,
whether the tribunal has the power of review?
Yes, but the power is incorporated under the statute.
Is there?
But otherwise, my lord, I could not have, I could have said up to this court.
There is a provision is for
the provision has been included. That provision has been included. No, I'm not. I'm reading that's not there.
That is the finding, Lord.
Where is the power of review, Mr. Ghosh?
Yes, I'm sure.
Show me the finding that the cannot review its own judge.
At this stage, well, he is not.
No. The tribunal says cannot review its own except in very exceptional cases. So the tribunal did not say it does not have the power.
No, that for that reason he has to say
exceptional cases.
5 years they come for that is
that is very entertained. That is very condoned.
If a decision was based on a document produced by you, if you cannot produce that document, it's a good ground for review.
But I will.
Yeah, I agree.
That he will give, but
no, that is the thing. That is the evidence said, but at this stage, it cannot be.
Mr. Ghosh, there is no scope to pass any interim order.
I understand what my lord is observing regarding that because it is rigid. But the thing is this: then some sort of in the nature of certain the order may pass because ultimately Because he is saying,
Mr. Ghosh,
what he is saying, because the two things are coming up, because at the stage when he prefer an appeal.
No, what is the interim order you have paid for? Staying the operation cannot be done.
Well, I'm submitting, staying the operation is not, but that you also make it clear at the stage when the appeal was preferred, you also knows, my lord, he has to deposit on the valuation decided by the first authority.
Yes.
They deposited.
That they have done.
They have done. Now, after the benefit was given to them, then I am to change that amount of annual valuation. Amount of annual valuation, if I change it, then my lord, I am to reduce the tax amount also. No, that is the reason I am praying for the stay of the order. Then the amount of annual valuation to be reduced, tax to be reduced, then entire complication will arise at the end. Therefore, I am submitting to your lordship.
When the order of review was passed?
My lord, review was passed, my lord, the 2nd September 2024.
2nd September 2024. And when the original order was passed?
Order in 2020.
2020.
But then I filed an application for review, and that was not.
So you serve him a copy. So I'm keeping it under the heading motion. Serve him a copy. When this matter is taken up for hearing, the learned advocate appearing for the opposite, the learned advocate appears and submits that he has instructions to appear for the opposite party. First of the learned advocate on record of the petition is directed to serve a copy of this application upon the learned advocate on record of the opposite party.
Make it.
When?
LC takes a Monday.
Copy service when?
Immediate.
In course of by tomorrow.
Record is, my lord. LC record.
Thank you. Please for it.
Well, if you instead of because if the matter is seriously hard, it will be the motion stay. But if it goes the monthly list,
it is on the motion. I'm keeping it under the motion. Yes.
Kindly check I come to page 34.
34.
34. Malad appellate court paragraph 10 malad. Malad wrong advice. Fine malad.
There is not.
And page 10 paragraph 10 malad.
Yes.
Liberty to the appellant to challenge the order of trial court refusing police help by.
What was the order challenged in the appeal?
Thereafter, my lord.
What was the order challenged in appeal?
17 March 2021.
What was the nature of the order?
Police help. I'm paying for police help after the order of injunction, injunction. I'm paying for police help that was refused. And now, my lord, I'm instructed that temporary injunction order was passed in my favor, my lord.
You have sought for police help for ad interim order of injunction.
My lord, that time.
So I'm giving you liberty to file an application for police help for implementation of the temporary. Ad interim, nothing.
For boundary was my sanction plan with me, my lord. No title interest of the defendant, my lord. My application, page 90. An original order of ad interim injunction, page 70, 80.
Where is the order of temporary injunction?
That order, my lord, not today, not with me, my lord.
All right.
Temporary injunction, my lord, I came to learn from London Advocate Calcutta.
This application under Article 227.
Number 28.
Yes.
My lord, it is for the expeditious disposal
Of what?
surface application pending.
Surface application.
We are for not for the surface applicant, my lord.
You are for the bank.
I am for the bank, respondent bank therein. Why, my lord? I have come before you. Moreover,
surface application proceeds.
My lord, kindly cease, my lord. There is an order of this honorable court, my lord, for expeditious disposal of that essay.
Not complied with.
Passed in a writ petition of
File a contempt application.
my lord. My lord, kindly cease. Page 22, my lord. The ordering portion is at page 23, my lord. Paragraph 10.
This order was passed in 2023.
2023, my lord. Thereafter, what happened? The bench was vacant till December 20, till the first week of December, it was vacant. The bench resumed charge in first week of December.
At that point of time, you applied under
yes.
You applied under 226. Now 227. Why?
No. But
what's the
election was for a superintendent's power was exercised.
No, at that point of time, it was 226.
I applied not for early disposal, my lord. I applied because the DM was not passing the order under section 14. DM was not passing. Against the inaction of the DM, I applied under.
There an order of expeditious hearing was passed.
Expeditious hearing was passed, my lord.
Yes.
And my lord, this order was also brought to the knowledge immediately of the bench resumed in the month of December. My lord, kindly cease my application.
Yes. What is the next date fixed?
Next date fixed is on 1st September, but kindly cease the order
of September.
1st of September. Due to a paucity of time.
No. The interlocutory applications have been disposed of.
I have
no interlocutory application pending.
No, my lord. Only the essay of main hearing of the essay, but surface application.
So 1st of September is fixed for hearing.
1st of September, my lord, kindly cease the orders one after the other, my lord. Due to paucity of time.
This
Again and
application
again.
Yes. None appears for the petitioner at the time of
Item number 30. My lord, may it please your lordship, my lord. My lord, I have never seen a bad order like this, my lord. My lord, the short case is, my lord, I am suffering an award.
You have a bad case.
My lord, the order is bad. Never seen such a bad order. Well, just 2 minutes, lordship will understand. Then lordship goes to the impugned order. My lord, I am a stockbroking house. I am suffering an award in terms of, my lord, an arbitral tribunal formed under the regulation of SEBI. So I am suffering an award of 37 lakhs. Now, my lord, I filed application under section 34 before the commercial court. Now, in terms of the SEBI guidelines, I will show before filing, I have to deposit 100% of the amount secure with the SEBI that I have done. With the stock exchange, I have deposited 100% and secured the award. Now, there is another clause. If I don't deposit, even if I deposit, who has got the award holder can withdraw the money. So if you deposit, they can withdraw the amount. I don't get a stay within some time before the. Now, I went to the commercial court, filed an application under 36(2), saying that, see, I have already secured the award, and in terms of 36(2) also, I am going to place that. If I secure, the stay is automatic. No matter what the impugned judge did, she imposed a bank guarantee of 37 lakhs in addition for staying the award. Yes, my lord, kindly look at, my lord, and then, my lord, if lordship, my lord, kindly look at the impugned order, my lord. The caption application has been filed under such and such.
That is the order dated 18th of August 2025.
Yes, ma'am. Lordship says, Learned Counsel for the petitioner has submitted, allowed the respondents arising of such and such. Now, my lord, it's the award portion. Kindly come to the second page of the impugned order, third paragraph. It is the further case of the petitioner. The petitioner, as per clause 4, clause 24 of Master Circular, the petitioner already deposited a sum of 3740 with National Stock Exchange of India Limited. The exchange being amount awarded under the impugned arbitral award. In terms of Master Circular, the same amount shall be released in favor of the respondent unless the court is pleased to pass an operation of enforcement of the impugned order. Therefore, adjudication issue of this court is whether this award can be granted or not. Then, my lord, she records 36(3) is the how it should follow. Then, my lord, lordship, see, on perusal of such and such of the award, it is stated the act provides this court may stay operation of arbitral award subject to such condition as it may deem fit. The proviso of the said subsection 3 stipulates that in case of an arbitral claimant for payment of money, the court shall regard to provision of stay money decree, order 41, rule 5, CPC applicable. The security has to be given is to satisfy. More so, my lord, judgment reported. I have not placed it, my lord, but she herself given. My lord, I have already deposited 100%. Therefore, the court is of the view to grant a conditional stay of the arbitral award on this case in the instant as it is found without accruing interest. The sum happens to be admissible claim, value of the error which needs to be stayed, that the present application is hereby allowed ex parte and the impugned award is hereby stayed during pendency of the application 34, subject to deposit of such and such by the petitioner in form of renewable bank guarantee in favor of a respondent within 15 days. Passing of such order, that a person will be vexed twice. A person.
Show me the.
The circular, lordship will find. The circular is at, my lord, kindly grant me a moment, my lord. Kindly come to, my lord, page 99.
91
It starts from page 91. My lord, I am taking your lordship to the. My lord, 3 clause, my lord, just, well, I am supposed to place before your lordship. 23, 24 and part of 25. My lord, upon, has your lordship got that, my lord? Page 98, last 2 lines. Page 98, last 2 lines.
Clause 23.
23, 24 and first part of 25. Well, upon the conclusion of arbitration proceeding and issuance of the arbitral award subject to the terms of the arbitral award, when such arbitral award requires payment of any amount by the market participant or performance by it in the certain nature, then such payment shall be made by the market participant within 15 period of 15 calendar days from the date of arbitral award, unless such award requires payment sooner, and or performance within such period as specified by the arbitral tribunal. The MIA shall monitor the due payment and adherence to the terms of the arbitration award until due receipt by the investor and or performance of the terms of arbitral award. In the event parties do not comply with the arbitral award, the relevant MIL, that is me, shall inform board regarding such. No, that is the authority. That is the authority for such non-compliance of periodic basis. Furthermore, provide necessary assistance to the investor client for upon issuance of pronouncement of arbitral award, the party against whom award has been passed will be required to submit its intention to challenge the award under section 34 of the arbitration conciliation within 17 calendar days in the ODR portal. Forward notification to the parties whose favored article order has been passed. Relevant in fact that in course of challenge, if a stay is not granted within 3 months from the date of receipt of the award, complete adherence to the terms of award must be done. If market participant wishes to challenge such award, then market participant must deposit 100% of the amount payable in terms of the arbitral award with the relevant MIL prior initiation of the challenge. In case specified intermediary fails to deposit the amount, they may also face consequence as determined necessary. Then my license may also get suspended and liable to be declared not fit proper in terms of SEBI regulation. Liable to have a listed company fails to deposit the amount may also consequence. All application made by the investigator from the depositor release such amount to the not exceeding or such sum as may specified. So it's mandatory. Now kindly come to page 119. Page 119. Well, here, I showed. That has been issued by. Lordship will see. From them, it's requesting me to deposit. Last paragraph, in view of the above terms arbitral award, would attempt to debit admitted in favor of investor with interest amount from exceeding dues of such and such. You are requested to kindly confirm whether adequate funds are available in such and such. Then I have given on page 121, Lordship sees, we confirm receipt of the payment. So that is not in dispute. I have secured it in the entirety.
Yes.
Now, my lord, if Lordship sees the proviso, the proviso says, 36, the learned judge with deepest respect, a copy the actor, Arbitration Act. Arbitration Act copy? Arbitration Act copy?
Yes. 36 proviso.
Lordship, kindly see, 3 and proviso. Upon filing of an application under subsection 2, 3 I am placing. 2 is setting aside, now I have to file an application. It's after amendment in payment on a separate application under provision of subsection 3 for stay. Upon filing of an application under subsection 2 for stay of operation of the arbitral award, the court may, subject to such condition as is may deem fit, grant stay of operation of such award for the reason recorded. Provided the court shall, while considering the application for grant of stay, in the case
so,
of
Mr. Nag, in this Arbitration Act, there is no provision for depositing, making a pre-deposit.
No. If you only ask for stay, then only the principle of Order 41 Rule 5 will come.
That is a different thing altogether, because in I think in MSME Act there is a provision that you have to deposit 75% or something. So here there is no provision.
Here no provision, but the SEBI regulation under which it has been
said 100%.
100%. So
full protection is there. That has been complied with.
And proviso is complied with. the proviso, order 41, rule 5.
According to you, the proviso to 36(3) stands complied with by virtue of compliance of
The 100% payment.
clause 25
Clause 25.
of the master circular.
Yes, I say, my lord, I will say, my lord, one step further. This, my lord, the SEBI arbitral proceeding has adopted it and made an inbuilt circular to safeguard the investors. So that has been done.
You
Well,
not suffer any prejudice. When the other side.
Well, the other side is not to be prejudiced. So there has been complete compliance. Well, now she is asking.
Here, so here is a thing because under 36(3), so any security that can be by way of a bank guarantee or anything else. But here it says you have to deposit.
But I have already deposited.
No.
Yes.
Here you have to, it's not security only. Here you have to deposit. So 36(3), the court has the discretion to direct.
There are judgments to the effect. I also can deposit my landed property.
Yes.
That is not the issue. The issue was
That is why security, but here is deposit. So you have to make the payment.
Payment, and I have made the payment entirely. In spite of that, a person, this is elementary proposition of law. Well, a person cannot be vexed twice.
Who is appearing for the?
Well, it's ex parte. First time I move ex parte because of the urgency. Lordship seen 25. If I don't get a stay, they can withdraw. So that is why I moved it ex parte. If Lordship wants,
They will not suffer any prejudice.
in any event, the other side will not face any prejudice because entire money is deposited.
The petitioner filed a
It was in court.
listed
Item number 29, your lordship, I was in court number 28, all your lordship.
what can be done? None of you are present.
Please register the matter, I was in court.
29 ta din. File din. Yes. Restoration, you have to move. Otherwise, that order will remain. No adjournment.
So, Passover, I have.
That can be done. Yes. Yes, call the next matter.
Number 31.
I am for the petitioner. Lordship, the wife is the petitioner before your lordship in a suit for dissolution of marriage by mutual consent.
Dissolution of marriage by?
By mutual consent, lordship.
Yes.
There, what happened, lordship? The wife is now staying at the USA. So, lordship, she wants to give her evidence, lordship, online, lordship, via some virtual platform. So, she made
That
an
is
application.
permissible. What happened?
So the learned trial judge said that there is a notification of this honorable court, but that was not given effect into, so rejected my application.
What is the notification?
Lordship kindly comes to page 25. There are the rules for video conferencing of courts, and Lordship 1.1. Lordship kindly comes. These 1.1 at page 25.
Yes.
These rules shall apply to such courts or proceeding or classes of courts and proceedings, and on and from such date as the High Court may notify in this behalf.
Notification has not come.
No, that is the lordship. The learned trial judge has said so.
No evidence is being allowed to virtual mode.
No. But lordship, in other cases they are being allowed, but this court
That
did
is-
not allow. Yes.
Where is the husband?
No, he's staying here. Then may I?
Representing the husband.
Say, lordship, they are not appearing. So may I serve, lordship? A very short day, lordship.
Please serve. What is the next date fixed? 6th of September.
6th of September.
So both the parties are willing.
Yes, yes. Even lordship kindly sees the impugned order. The husband also didn't have any objection, lordship.
Can you serve the husband?
Yes, yes.
About the identification of that person. That's the
Yes,
difficulty.
Lordship, maybe not by WhatsApp call, but Lordship, there are procedures that in the consulate, Lordship, I shall go, and Lordship, there I
Yes,
shall.
that
Even
is,
my client is, Lordship, willing to do so also.
cooling off period has also been waived.
Yes. By your Lordship.
Number 23.
কি বললাম? Rejected and the petition ওটাকে দেখার দরকার।
Item number 32. 32, I beg to appear on behalf of the petitioner, Lord. Lord, plaintiff is the petitioner before your Lordship in a suit for declaration and injunction that he is the lawful owner of the property and defendant is trying to, my lord, dispossess him. Now, my lord, in such a suit, my lord, initially, my lord, injunction was refused, Municipal preferred. Municipal court was pleased to pass an order of status quo with regard to nature, character, and, my lord, possession. Now, my lord, what happened thereafter, my lord, two applications have been filed by the plaintiff. One is, my lord, under Order 39 Rule and Rule 7 for appointment of commissioner for repairing of the roof of the property. And my lord, the second application was basically it's a modification of the injunction order. Further injunction that, my lord, the defendant may not, my lord, cause any hindrance or disturbance while, my lord, causing repair. These two applications preferred. Now, my lord, initially, my lord, these two applications was rejected. Thereafter, my lord, Municipal again preferred. Municipal court, my lord, rejected, turned down 39 Rule 7 on the ground that order is not applicable order. That's a reversible one. My lord, I am not disputing that for the time being. The second part of the
timing means subsequently will dispute.
my lord, that my lord, 39 Rule 7, my lord, I have a remedy, my lord, by way of revision. My lord, now, my lord, the second part of the order, my lord,
Modification.
Yes, my lord, the learned judge refused, my lord, why my lord has refused? Lord, you can see the order in for once, paragraph 11 and 12. My lord, the learned judge is of the view that since, my lord, I have, my lord, in possession, I am in possession on the basis of a notarized document and, my lord, in which capacity I am in possession, I have failed to.
Show me the original order of injunction.
Yes. My lord, Lordship, kindly see, my lord.
This is the on modification.
Yes,
this is not modification. Show me the original order.
My lord. My lord,
What is the suit for?
Suit for, my lord, declaration and injunction. Lordship, kindly comes
what is the declaration sought for?
I am the lawful occupier, my lord. Lordship, kindly see.
Lawful occupier?
Yes.
In what capacity?
My lord, my contention before the learned court below was that, my lord, I have paid, my lord, 10 lakhs of amount. My lord, I have handed over possession. My lord, to that extent, my lord, my
10 lakhs you have been handed over possession.
Yes. Lordship, kindly sees page 16 is
by what document?
Yes, I have a notarized document, notarized agreement. That, my lord, I have.
Can you protect possession by way of a notarized document?
Yes, I can inform, my lord. My lord, that document, that I can
protect your possession by way of
I am in
notarized
possession.
document.
My lord, I am in possession. That is an appeal.
Can you protect possession by way of an order of injunction? I'm asking you.
My lord, I have got an order of injunction.
Maybe.
My lord, that judgment, my lord, your lordship, my lord, is
protect possession in part performance
Yes.
by virtue of a notarized agreement. Please satisfy me on that.
Milord, that Milord, my humble submission, that part, Milord, I have already crossed, Milord. I have got an order of injunction. Milord, good, bad, independent, Lordship, kindly see,
It
Milord.
is so motor power, Mr. Chakraborty.
Milord, every matter, if your Lordship, Milord, exercises so much power, Milord.
Yes, can be.
Milord, Lordship, kindly sees, Milord, my Milord, plain for a moment, Lordship, kindly sees, Milord. Milord, page 16 is my declaration prayer.
Yes.
And Milord, averment, Milord, I have made, Milord. Paragraph 2 onwards is my averment, page 13.
Paragraph 2.
Paragraph 2, Milord, there was a deed of partition, Milord, in between, Milord, plaintiff, 3 brothers, and Milord, the predecessor in interest of the defendant. In the year 1993.
All right. Now, show me the initial
Now,
order.
Lordship may kindly comes to, Milord, I'll just take your Lordship one by one. Page 18, Milord, my initial order, Milord, refusing injunction. Milord, we need not. Lordship kindly sees page 20.
Yes.
Milord, the
relevant part.
Yes, Milord, the relevant part is at page 23. 23, 24 now. Operative part. Lordship kindly sees page 23, Milord, second paragraph onwards. On the other hand.
Oh, it's only a status quo order, Mr. Chakraborty.
Milord, possession is admitted. Milord, nobody.
Where is the finding with regard to your possession?
Yes, Lordship kindly sees. Milord, at the time of hearing, learned advocate appearing has claimed.
Which page?
Page 23, Milord, I am.
23, yes. At the time.
Learned advocate for the plaintiff appellant has claimed that the appellant is in possession of the disputed property. Though the predecessor of the defendants agreed to sell him the property, did not execute the deed, he did not file any suit for specific performance of contract, so there is no need to get the agreement properly stamped. He claims that he should not be evicted otherwise in due course of law. On the other hand, learned advocate for the respondent submitted that the plaintiff is a mere licensee. The document like agreement for sale cannot be executed only a stamp paper or rupee stamp, but it ought to be stamped according to the valuation of the suit property. In this situation, the dispute arises as to whether the plaintiff's status is only a mere licensee or he is actually paid the alleged amount in order to get possession. In the
status is in dispute, but possession admitted.
Now, Lordship kindly sees, Milord, the nature of order at page 24. Milord, second paragraph. Both parties are
Yes, I've seen that. Yes, next.
Now, Lordship kindly sees my petition under order 39 rule 7. For the time being, your Lordship may ignore page 25.
You can come
Yes.
to the
second Milord petition, Milord. May I just page 29. Milord, this is the basic prayer is at page 30. Milord, repairing the roof of the suit property. This is my prayer all about. Now, Milord, the court in the Milord, while disposing of my appeal, misappeal, Milord, initially, Milord, this Milord order of injunction modification, Milord, stands rejected. Lordship kindly sees, Milord, the trial court's order, learned trial court's order at Milord, order dated 23rd of August.
Where is the particulars of the repairing, Mr. Chakraborty?
Milord, the particulars of the repair, Milord, I Milord, bow down to your Lordship. Milord, I will give. Milord, I will give to the extent. Milord, the roof. Milord, the entire roof. I have stated.
You have not show me, Mr. Chakraborty, this is permitting you to repair. So first, it's the other way around. So first, local inspection, the picture has to be arrived.
Yes, Milord, I have also, Milord,
the court is satisfied. Yes, there is a necessity of repairing. Then the question of modification comes. It's not the other way around. Modification, yes. Then
Lordship kindly considers just other way around. Lordship kindly considers. Milord, in case, Milord, this injunction order is not modified. Milord, Milord, my entire application for Milord local inspection or Milord comes to
challenge the local inspection rejection. No.
Milord, as a, Milord, the learned judge, Milord, my humble submission is, Milord, the learned judge in the court, Milord, should have taken, Milord, my injunction modification application first, rather, Milord, considering 39 rule 7 on merit. Once I failed to satisfy.
39 rule 7 was rightly taken up first. Has to be. Because Mr. Chakraborty, the fact remains, your prayer for modification is consequential upon holding that there is a necessity to repair.
No, Lordship kindly sees it not
unless Mr. Chakraborty, let us assume for a moment that after the report comes, court finds there is no necessity to repair. would there be any requirement to modify the order?
My lord, had it
of
been that
injunction?
case, my lord, I would have bowed down before your lordship. Lordship kindly sees the reason given by the
Reasons can be supplied, Mr. Chakraborty.
No, Lordship kindly sees whether he
Reasons
had
can be
my lord,
supplied.
can be supplied. Lordship kindly sees, my lord.
Yes.
23rd of August 2023's order, Lordship. My lord, just one page order.
Yes.
My lord, may I just read? My lord,
This is
today,
on what? This is on modification? No. This is on local inspection.
no, this is my lord a common order passed by the London Trial Court rejecting my applications. Lordship kindly sees. Both. Lordship kindly sees, my lord. Order dated 23rd of August 2023. Today is fixed for hearing petition filed by the plaintiff for local inspection and injunction. Both parties are represented by their learned advocates filing their respective hajiras. Accordingly, petition filed by the plaintiff is taken up for hearing. Firstly, it appears that the plaintiff has prayed for local inspection of the suit property with an intention to cause repair of the damaged roof, if any detected in the local inspection. He has also prayed for injunction against defendant as he apprehends that the defendant may cause obstruction in the repair work. Learned advocate submits that he is in lawful possession of the suit property and he has every right to make repair works therein for making it suitable for habitation. Defendants raise strong objection and submits that the plaintiff does not have any right to repair any portion of the suit property as his status in respect of the suit property is that of a licensee. He prays for rejection of both the applications. Having heard both sides upon perusal of case record, it appears that the plaintiff has prayed for local inspection to find out any damages in the suit property so that he can make repair works. He also appears to have been prayed for an injunction order against the defendant seeking a restraint order while the repairing work, if allowed, is undertaken to avoid any obstruction. It appears from perusal of case record, specifically order number so-and-so, dated so-and-so, plaintiff's prayer for temporary injunction was rejected. Milord, this is absolutely wrong, Milord. This temporary injunction was rejected due to want of proper legal title over the suit property. This finding is not completely wrong. You'll have seen that.
Prayer for temporary injunction was rejected.
Due to proper legal title,
but no, that prayer was rejected.
Lordship kindly sees then. It further appears that defendant's predecessor was admittedly the owner of the suit property.
Mr. Chakraborty, have you challenged this order of 23rd of August?
Yes.
Rejecting the local inspection?
No. No. My lord, my humble submission.
Second is, though in all local inspection, there is an element of fishing out evidence or collecting evidence in any local inspection, but you have to make out a specific case in the repairing application. So you have said local inspection, please do it, see whether repairing is necessary, then I will.
I'll come to my local inspection also. Lordship, for the timing, kindly, just go reading a few more lines, because Lordship, this is a very short order. A further perusal of the plaint reveals that the plaintiff was admittedly given the possession of the suit property by defendant's predecessor and plaintiff has nowhere specifically claimed as legal title on suit property. Given such state of fact, I do not find it pertinent to allow the application for local inspection filed by the plaintiff, which is hereby rejected on contest. Lordship, kindly see whether there is any finding with regard to my local inspection.
Local inspection you have not challenged.
No, Milord, the entire order. Milord, I tell you, Lordship. Milord, the entire order was.
There are two parts. One part is local inspection, other part is injunction. Local inspection, even if there is a wrong finding, not challenged.
Milord, the entire order was challenged before the learned Miscellaneous court. Milord, I'll come to that.
Cannot be.
Cannot be. Milord, I come to that. Milord, Lordship kindly sees now, Milord, the Miscellaneous court's order for the finding. Milord, this is Milord, there is no finding with regard to inspection. It has to be rejected. And Milord, there was a wrong finding that Milord, my injunction prayer was refused due to Milord, not sufficient, title was insufficient. These are the two grounds, Milord. Court has not dealt with the other aspects. Now, Lordship kindly sees the Miscellaneous for a moment. Milord, this is order dated 26th of March, Milord, 2025. Milord, I'll just take your Lordship, Milord, to the relevant part. It is a bit longish one. Lordship kindly sees. Paragraph 8, because paragraph 8, Milord, gives Milord the finding with regard to Milord refusal of Milord temporary injunction. There is a Milord specific recording that it was not possible for him Milord to reside in the suit property due to Milord the damage Milord caused in the roof of the house. then Lordship may kindly ignore the facts. Lordship may kindly come down to paragraph 10.
Yes.
After hearing the argument both sides at length upon perusal of impugned order, case record of this court, the application under Order 39 Rule 1 and 2 along with an application under 39 Rule 7 and their objections lying in the case record, the learned trial court, it appears that the learned trial court on the strength of impugned order dated 23rd of August has rejected both the applications as noted above. It is pertinent to mention here that an order refusing an application under Order 39 Rule 7 is not an appealable order under Order 43 of the CPC.
So that observation is correct.
Correct. Accordingly, this court in this appeal is not at all concerned with the rejection of the application under Order 39 Rule 7 so and so. Now, this part, I can challenge even,
Till now not challenge Mr. Chakraborty.
I will get the benefit of section 14 and all. Your Lordship knows because of wrong forum.
Mr. Chakraborty, that is there, but till now not challenged.
Your Lordship under 227 jurisdiction has the power to enter into and go through whether the nature of repair I have sought for is at all necessary or not.
The nature of
I'll just come, I'll just show you.
I've seen the order. I've seen the order. Paragraph 11, yes.
Surprisingly, the plaintiff has filed the application under Order 39 Rule 1 and 2 before the learned trial court, praying for restraining the defendants to cause any interruption at the time of repairing of roof of the suit premises. It is all along roof, not the entire suit premises. But at the time of argument, the learned advocate for the plaintiff has been trying to project that he has filed an application praying for repairing of the suit premises. Wherefrom the learned judge has observed, I do not know.
Yes, you have paid for repairing of the suit premises.
Can ignore because the submission from the bar will not be taken into consideration because my application is specific. Yes. I wanted repairing of suit premises, not the entire premises.
No, suit premises.
The learned judge has recorded that while at the time of argument, learned advocate has been trying to project that he has filed that application praying for repairing of the suit premises. Yes. Which is my humble submission is not correct because my application was all along with regard to roof.
Roof is a part of the suit premises.
That is the rejection.
Don't be that technical.
That is the reasons for rejection. Lordship kindly says I'll go on reading.
You mean to say roof is not part of the suit premises?
Not the entire suit premises.
But the entire suit premises.
Lordship kindly says the rejection, not the reasons. Lordship kindly sees the reasons.
Yes.
Thereafter, this court finds it judicious to confine its consideration within the application under Order 39 Rule 1 and 2 and prayer of the plaintiffs therein. Admittedly, the plaintiff is in possession of the suit premises, but the plaintiff has not mentioned anywhere of the plain that in what capacity.
The sum and substance of the appellate court's order is that, yes, though you are in possession, but in what capacity that you have not specified, you could not prove. On that ground,
my humble submission, I am asking this question to myself, is it a consideration for rejecting the prayer or modifying an order of injunction?
Right, I will come to that. Please show me that your repairing application.
Now, Lordship kindly comes, that is the only thing, I will just show.
Yes.
Because, I cannot improve my case. Lordship kindly sees 39 Rule 7 application for a moment.
No, 39(7) you have not challenged till now. So, repairing, show me the application for repairing.
No,
39(7) you have not
as of now, there is no application for repairing. I have only taken out applications.
No, repairing is there, page 30, 29.
No, page 29, Lordship kindly sees.
Yes, it's Order 39, Rule 1 and 2.
Yes, this is the Lordship kindly sees page.
They are also not happily drafted, Mr. Chakraborty.
That is why I am saying,
you are technical on the expressions used by the learned trial judge.
But this
is your application. This is your prayer.
Lordship kindly sees the sum and substance
for modification. Nothing.
It is itself a modification. Lordship kindly sees, if this application is allowed, then the original order of injunction has to be modified. Now, Lordship kindly sees, under what circumstances and contested order of injunction can be modified. 39 Rule 4 will come into rescue. 39 Rule 4 is the only where the injunction order can be modified. Under what ground? Lordship kindly sees. When there is a contested hearing of injunction.
Yes.
May I just read, Milord? any order for an injunction may be discharged or varied or set aside by the court. Milord, here, milord, variation of the order, milord, we are seeking. On application made thereto by any party dissatisfied with such order, provided that if an application for temporary injunction or in any affidavit supporting such application, a party has knowingly made up false or
Keep that proviso, that is ex parte. You can come to the second proviso.
provided further that where an order of injunction has been passed after giving a party an opportunity of hearing being heard, order has not been discharged, varied or set aside on the application of that party, except where such discharge, variation or setting aside has been necessitated by a change in the circumstances or unless the court is satisfied that the order has caused undue hardship to that party.
Show me change of circumstances.
The change in circumstances is the
show me from your
cost in the roof.
Show me from your
that-
application.
Milord, I have
Mr.
made
Chakraborty, show me from your application. You have made this application within the scope of Order 39, Rule 4.
Milord, page
second
29,
proviso.
page 29, paragraph
Nothing.
2. Page 29, paragraph 2. Only answer, Milord, to your lordship's query. That during
That's vague.
Milord,
Mister,
lordship has.
You have to make out a specific.
Milord, the
case,
learned
Mr.
judge in the court below, had it been a case that has rejected my application on the ground of vagueness,
In order to make out a ground under paragraph 2, first is local inspection. Unless that, you have to prove that it has been changed. Subsequently, this is the nature warranting
this is a
modification.
subsequent change, Milord. Milord, lordship kindly sees, Milord, the averment during pendency of the suit, property is damaged and it is
Mr. Chakraborty.
Milord, it is impossible to reside in the suit property. Milord, what more I can, Milord?
Yes, yes.
Lordship kindly sees, Milord, I am in possession.
No other material.
Milord, there is no other material, Milord, but Lordship kindly sees the nature of Milord, the rejection is based on, Milord, the legal status of.
You are not
Milord,
interested in challenging Order 39, Rule 7.
the 39 Rule 7, Milord, I
Till now
challenge.
you have not challenged.
Milord, Lordship kindly visualize movement. Your Lordship, Milord, is, Milord,
I am asking you, Mr. Chakraborty,
Milord,
are you interested in challenging Order 39, Rule 7? Yes or no?
Milord, I am interested. Lordship kindly sees, Milord, one particular point, Milord, I will be addressing. Milord,
So
Lordship
what
kindly
will
sees.
be
Milord, what is Milord, position of
Then I will proceed the matter as it stands. That
So,
is
Milord,
why I
Milord,
purposely
Milord,
asked you.
Milord, this is for myself, Milord. I am just, Milord, placing, Milord. Milord, in case, Milord, Order 39, Rule 7, I challenge. Milord, this is a subsequent challenge. Milord, your Lordship's order will be staring at our face because, Milord, the learned judge in the court below.
That is why I asked you, Mr. Chakraborty, please apply your.
If your Lordship grieves liberty, then I have to challenge and I want to challenge. There is no doubt, but Lordship, Milord, kindly clarifies that, Milord, I can challenge. Otherwise, Milord, this is a contested hearing, Milord, where, Milord, my application has been turned down. I cannot make further prayer for, Milord, modification.
The Order Rule 7 has not been challenged.
But, Milord, the 39 for the observation passed by the learned court below has come to an end. If your Lordship, Milord, kindly clarifies that shall not preclude me challenge.
Mr. Chakraborty,
Then, Milord, I can.
what is your paragraph 4 at page 30?
Paragraph 4.
Yes.
Yes, Milord, for repairing of the suit property.
Yes.
Milord,
You are
that is
saying the learned trial judge has proceeded on the basic suit premises. You have not paid for that. Paragraph 2 says roof. Paragraph 4 says suit property.
Yes, Milord, suit.
So you are saying the learned trial judge proceeded on the basis of the argument, should have considered.
She kindly sees the prayer. Milord, clarify everything. Milord, repairing the roof of the suit property.
Yes.
Milord, roof is also part of, Milord, the.
Yes, what do you have to say on the local inspection? Yes, move that.
Local inspection.
Yes, yes.
Lordship
Move your
kindly sees.
application. Because the order is there. So much
Lordship
power
kindly
to
sees.
take
Yes,
effect
Lordship
on-
kindly sees, Milord, page 25 is my application for local inspection.
Yes.
Milord, paragraph 1 and 2 need not be looked into because advocate.
Page 25.
Page
Yes.
25 it starts. I'll just Lord, straightway request your Lordship to kindly come to page 26. Lord, the prayer. Appoint an advocate commissioner and for inspect the schedule noted points and to report and be pleased to pass such orders as your honor may deem fit and proper. Now, Lordship kindly sees the schedule at page 28.
Yes.
Draw a rough sketch map. Lordship kindly ignores the spelling.
What?
Rough.
No, all right. That I have to ignore everything, Mr. Chakraborty. When you proceed towards your schedule, I have to exclude everything.
Sketch map of the suit property.
Then suit property, not the roof.
Then Lordship kindly see
Yes.
to note whether the roof of the suit property is damaged, it should be Lordship kindly ignore second.
Yes, yes.
To note
Nothing is left. If everything is ignored, Mr. Chakraborty, what is
Milord,
we
the
can see
English
that?
is Milord not properly. Milord.
Yes. Any
To
other
note any other
features?
feature or features as it should be shown by the
Yes,
parties.
yes.
Now, so Milord, Lordship kindly considered this, Milord. This is Milord, sum and substance of the repair was basically Milord concentrating on the roof of the suit property. It's not that the entire suit property. Milord, I am in possession, Milord. I want
What do you
Milord,
say?
The first thing is, Chief, my learned friend is here, my lord, is my lord, describing the application for injunction as an application for modification of injunction. And my lord, in the trial court, his counterpart said it's an application for repeal. So Lordship kindly see that what my learned friend has tried to emphasize to the Lordship, that the suit premises, my lord, this filed application saying for repairing of the suit property, the projection was that. The projection was that because the application was actually an application for injunction to injunct a true owner from disturbing the work of repairing, whatever manner he will want to do. And manner he wanted to injunct this is not an application for repairing or schedule has been mentioned.
What is your objection to the inspection?
That has been rejected long back, and thereafter, your lordship, if he is in such hurry, but the appeal court's order was passed in
No, he has challenged that in the appeal court also.
The appeal court's order went past, your lordship, can you see?
When?
In 23rd of your 23rd of that was in
No, appeal court's order
26th
when?
of March, and they have come in August.
It
If
is
that
March
event
and March and
Sorry, was if
March and August. You are so serious.
sorry, if there was
All right, I will remember that.
if they were in such a lordship, there is no statutory limitation for
That
the
is why.
227 application.
That is why he has challenged that, and it has been held that.
My first round of objection, your lordship, kindly take the injunction application for a moment, your lordship, page 29.
Have you filed any objection to the repairing application? Where is that?
My first contention, and I'm giving my let me my first contention, your lordship, kindly see page.
What is your objection, sir? He is in possession. If he repairs, what is your objection?
My lord, the first thing, the application for injunction, my lord, nothing has been stated. My lord, nothing that there was an order of injunction which was initially administrative order of injunction was granted. The injunction application was rejected. Thereafter, in the misappellate court, the injunction was granted. Nothing has been stated. That even if the injunction was granted in that event, my learned friend is saying about order 39 rule 4, the order of injunction, if he at all got, my lord, that order is liable to be set aside or varied on the ground of suppression of that. Nothing has been stated in the application for modification of the injunction. Well, I'm giving that. The second ground is, lordship, kindly take page 29, para 5 for a moment. The injunction application. What is this ground for, my lord, praying injunction? The page 30, para 5. The defendants may create obstruction at the time of repairing for which the plaintiff complied, should be compelled. That should be ignored also, my lord.
Everything will be ignored.
It is required to be ignored, my lord. Just be understood that he has, my lord, tried to write compelled to file this petition. Completely speculative application. The cause of, and that was the ground of rejection, which has not my learned friend has pointed out. Your lordship, kindly take the order impugned. Your lordship will find in paragraph 12 that it is a premature application for injunction. No repairing application has been filed. He filed an application for my lord, to injunct a true owner from doing whatever he wants to do, and my lord, on the apprehension that I may stop him, and that injunction is required to be granted.
Anything more?
But one more point, my lord, I'm showing, my lordship, that is third, my lord, I'm showing. The third point is, lordship, what has fallen from your lordship. I don't want that to repeat.
Don't rely on those observations. You can make your submission. That was to counter Mr. Chakraborty.
Order 39, Rule 7 application, your lordship, they have stated, my lord, learned friend has stated that the learned trial judge and appeal court ought to have, my lord, decided 31 and 2 first, and then 39-7. That was a mistake.
According to you, Order 39 Rule 7 ought to have been decided
That is
first.
their statement. That is their statement. Lordship, kindly come to page 26 for once.
26?
Yes. That is their application. That their statement. The paragraph 2. that for substantial allegation in the petition and an order 39
Oh, yes,
one
yes,
of the
yes,
application,
yes.
the advocate commissioner is required to, my right has been accrued after dismissal of 3 years. Now he is want to challenge taking section 14. But if this kind, if my lord, your lordship can so moto invoke lordship's power to 27, then my lord, I will argue on the injunction point. This injunction cannot sustain. What is this title behind that? 10 lakhs, then your lordship kindly also entertain my argument on the point of injunction.
Ashok.
My lord, only impugned order, my lord, records that he defendant raises objection. My lord, I do not find, my lord, I did not. And my lord, so far as my lord, the scheduled part is concerned, if my learned friend so my lord is apprehending that I can my lord change and raise a new construction, my lord, your lordship can my lord appoint anybody from here. My lord, he will in his presence the my lord, it can be done.
Eviction is pending.
Yes, what he is doing, my lord, he is trying to crack the suit,
Lord,
create some
eviction,
so that the
eviction doesn't mean that I will get a degree. That you will get a degree.
So that the injunction order continues and my lord, if there is some ambiguity in the order of eviction,
Ashok,
this
Ashok,
clarification has
this application under Article 220 Item number 33.
33 three orders.
You are challenging 3 orders in one civil division of place. How?
No, Milord. But I will take your lordship's kind attention. The impugned order 11/7/2025.
3 orders cannot be challenged.
No, not challenged.
একটা কোর্ট থেকে 3টে অর্ডার চ্যালেঞ্জ
Cannot be done. How many court fees? How much?
I am challenging only one order, Milord. 11/7/2025.
Now you are saying one. You said 3 orders.
3 orders are required to be placed before your lordship.
Yes, you are challenging only the order dated 11th of July.
11th of July.
What is the nature of the order?
Order, Milord. Milord, before that, Milord.
This is a guardianship matter. Mr. Bose, now you have specialized in recent times in guardians and Watts Act matters. You are specialized in this field. Yes.
Milord. Milord, before
Yes,
your
what is the
lordship.
order? What is the impugned order?
Impugned order, Milord. This is the page 263, Milord. There is the 11/7/2025. Milord, this order does not take note of, Milord, the 2 previous orders, Milord, dated 20.
Who are you?
Milord, I am the Milord biological mother, Milord.
You are the
Mother.
You are the mother. Mr. Chakraborty is opposing this. No caveat. Yes.
Now, Milord, what happened? Initially, Milord,
by this order, what has been done?
By this order, Milord, they say, Milord, that the father has the visitation right of the father, Milord. That is, Milord,
that has been allowed.
Allowed. I don't
objecting
no,
to
no,
that,
no,
Mr.
no,
Bose.
I am not objecting. Kindly, that is why, Milord, I require your lordship's kind attention to the 2 orders, Milord. 27/9/2025.
What has been done by that?
Milord, that order, Milord, says, Milord, initially, Milord, there was the meeting on a virtual mode. There was a disturbance. The child did not. And 176, Milord, the child did not want to interact. Now, Milord, what happened? The court called the child. Court personally interacted with the child. The observation of the order, the court, Milord, after personal interaction, that is December 2024. The court specifically says the child does not want to meet the father. Now, what happened? After the dissolution,
Mr. Bose?
I tell you, Lordship.
Are you responsible for that?
No, I am not. Kindly see what I said, that December 2024, when the child interacted with the judge had recorded its finding. Then, Milord, an application for modification was made by the erstwhile husband, Milord, saying
erstwhile husband, divorce has been degree of divorce.
Yes. Now, Milord, the mutual consent. Milord, there was an agreement. Memorandum of settlement, Milord, incorporates a clause which entitles father, Milord, so far as the visitation is concerned. The father,
the age of the child?
9 years.
Son or daughter?
Son. Now, Milord, what happened? During the interaction, Milord, the child had expressed its mind. Now, the Supreme Court, Milord, had said in one judgment, Milord, there is nice sentences, that if the age, a child aged about 9 years, Milord, can exercise his choice and discretion also. 1. 2, Milord, that there was no attempt on my part to, Milord, create any impediment so far as the visitation right is concerned. What I had said to the court, that my husband, Milord, says that he will facilitate, Milord, the visitation. Milord, after divorce, my client, the wife, does not want to see, Milord, and meet, Milord, or make any interaction, Milord. There is with my other husband.
That maybe, but
No.
Mr.
Question is, I am not saying for this reason I cannot, Milord, create an impediment. I said my son is, Milord, does not feel any compatibility conundrum. He feels easy and he stays in a comfort zone so far as my husband is concerned. Stepfather, the stepfather of the child. Stepfather facilitates. Stepfather, Milord, takes the child away. Child is suffering from trauma. Now, Milord, the belonging and his freedom, child's right also, Milord, when the court says, Milord, that the paramount welfare of the child is the welfare of the child is the paramount consideration, possibly court is not oblivious of the fact that the child's individual right, his sense of belonging, his right to exercise freedom, court cannot, Milord, lose sight of this. I said as a stepfather that I will facilitate, I will take him there. And, Milord, my wife does not want to, Milord, make any interaction with this gentleman. And
And in the court record says third party is not allowed. Court must, my lord, must not be unmindful of its times that due to the change of relationship, due to the change of climate, the court, my lord, must take an approach which is pragmatic. I said I want to facilitate. I said the stepfather of the child will go. The court did not take into account, and court modified the earlier order without taking note of before. The child and court did not bother to interact with the child.
Mr. Bose, the child is also not familiar with you.
Child is familiar. Child is, Miller. I repeat, Miller. I am a mother. I said
That is why I am asking you.
No, the child is not. It is not my question with familiarity. It is a question subject to correction.
Is not comfortable with you.
No, child. I do not want my husband. I do not want to go there. Number one, I do not want to face. But the question is the court's order. I am bound by the agreement if that is the court's concept that you entered into a memorandum of settlement and on the basis whereof the
Mr. Bose, only for the purpose of safety and security, it's that you have to remain present. If not, if you say so that you do not allow to meet with the husband,
no, I
during the time of interaction, then I can direct, I can allow the father to take the child from your home, to take it
your lordship to return. If that is so, Miller, then your lordship is increasing the element of trauma in the child play. Because that is why I am making a request. 176 kindly read. That is why I requested your lordship. Miller, your lordship's perception. Your lordship's perception is not static. Your lordship, Miller, changes your lordship mind.
You are saying,
no, I do not want to meet your husband. No, that is one of the criteria. That is one of the criteria. But at the same time, I put emphasis on the child's right and child's trauma. 176. Kindly see, Miller, the father petitioner got the opportunity to son of the court premises. Thereafter, I interacted with the child. The child is a student class 2 of South Point School. He seems to be bright, interactive, and spontaneous. I had the opportunity to interact with him. Understand his mind. He seems to have no interest in his father. To look at his father, there's no such mind. After interaction,
at what age this separation took place? At what age of the child this separation between the father and mother took place?
6 years. Before that, maybe he was an absent father. The father's presence in the child's life, Miller, was conspicuously absent when the child was at the age of 2 or 3. The father did not take care about. There are certain compatibility conundrum, Miller, arising out of the father's personal lifestyle.
To serve Mr. Bose, interim order cannot be passed.
No, Miller, kindly sees. I want to facilitate it. Again, Miller, I say, Miller, kindly allow the stepfather to take him in the GP's chamber, Learned Government Peters chambers, in presence of Miller, the third party. I will not.
Mr. Bose, I am asking you, as an officer of the court, not as an advocate of your client, do you feel that a court premises is a suitable place for an interaction between the son and the father? I'm asking you.
No, the court had said so. The court had said so.
That is why I'm asking.
No, the GP's chamber will be, Miller, that will be separately placed for this, kept for this child interaction, that they have shown this generosity, that for the child's.
I'm not on that.
Miller,
Not
is it not my,
GP
Miller, am I justified?
I will not.
Miller, am I justified or correct, Miller, in pursuing to the highest court of the state, the honorable judge of the constitutional court, Miller, that will the court, Miller, be oblivious of the child's mentality or mental illness or health? I put this question.
Why?
Premises, father
will not be the suitable place, subject to what you say.
It is not possible. That is why I request your lordship, before your lordship comes to a conclusion, an idea might be flowing from the judge's mind that the mother has tutored the child.
No.
If that is not so, kindly make her.
Two things. One is whether who will accompany the child. That is one part. You are saying the stepfather can accompany the child. Second question is that I'm asking you, do you feel that court premises in an ideal place?
I would respond with humility. I would respond.
Maybe other better.
Absolutely, Miller. I bow down to my lord, Miller. Even then, Miller, maybe
if you want a presence of a special officer or other things, maybe there.
Where should you feel court premises? Right. I bow down. Before your lordship comes to a conclusion, give your lordships valuable 10 minutes time. Justice Basu Chaudhary also had interacted, my lord, in other matters where my learned esteemed friend was there. My lord, yes, in another matter. My lord, I tell your lordship, my lord, kindly have the charity to consider and spend your lordship's valuable 10 minutes time and kindly have the interaction. Kindly see, my lord, the child's, my lord, mentality. He is spontaneous. No, kindly in the meantime, direct, my lord, the mother and the stepfather to bring the child before your lordship.
Please, sir, let the other side first.
My lord, they will file a contempt, my lord. I have filed an application.
It's not being possible for us.
I cannot force my him. He's crying. He's absolutely crying.
No. Why contempt?
No, contempt because I will miss the date.
Stay there.
What is the next date? Mr. Bose, this order was passed on 11th of July. You took so much of time to file this civil division application, and today we are on 27th. 30th is the next date.
Certified copy was not made available. What can I do, my lord? I put this question to myself. Certified copy was not available. The certified copy, my junior has instructed me, my lord. So only, my lord, kindly says, my lord, I would request your lordship tomorrow.
Certified copy was made available. Mr. Bose, you have filed, affirmed this application on 13th of August 2025.
Yes, 11 and 11 July the order was
And
passed.
14th you have filed and you have given the presentation.
No, I my junior person mention করেছিলেন mention করেছিলেন.
It is appearing on the date when it is fixed.
I only say, my lord, let us not go into the other questions. Since your lordships, my lord, has put certain questions, and my lord, not only that, your lordship no, I am not asking in order. I am only saying, kindly, my lord, in presence of the father, the opposite party, my lord, kindly give us a chance to interact with the child personally to a judge. Kindly, my lord. I request your lordship so that your lordship can get the understand, my lord, the climate of the child's mind. Then, my lord, your lordship will pass. I leave it to your lordship.
So those
many times
recording is there, as we have said. The learned judge has recorded after interacting those recordings. There are previous orders are there, so that can be considered. That can also be considered. There are recordings. You are not disputing those recordings.
No, we are beseeching the court to consider. The court did not record our submission. We had to file an application before the court.
369 item number 29 you want to
Yes, please wait. Yes. That is that alimony matter.
Yes,
How much time you will take, Mr. Chakraborty?
at least half an hour, my lord.
Half an hour. Today it's difficult. I cannot continue for long. That's the difficulty.
Half an hour I'll conclude. Half an hour I'll conclude.
Today I do not have that half an hour. That's the difficulty.
Then Friday. Tomorrow there's a 3:30. Friday keeps it from Friday.
Tomorrow there's a 3:30.
I'm told normally it was decided amongst us. That's only before puja. Only Fridays will be 3:30. Tomorrow Friday there is some program in Bal Library. Tomorrow there will be 3:30. I'm told in the corridor. So হ্যাঁ তো ফ্রাইডে আমি কালকে ফ্রাইডে বলে নি না তোমার জুনিয়র নোট নেবে তুমি তারপরে সপ্তাহে বলো
What is this? What is this issue?
Lord, the issue is despite availability of 21-22 income tax return before the judge, the honorable learned judge has considered 2021 income tax return and has awarded 1 lakh rupee, 50,000 for the daughter, 50,000 for the wife. When the husband earns 50 lakhs a month, 1 crore 70 lakhs, my lord can understand he has appointed Mr. Mukherjee. He travels in private jet. I have those copies.
For your argument, but when you see what order he is challenging, it cannot go beyond the order which he is challenging.
Okay, I know what I can do and what I cannot do, my lord. Let me place my case.
So if you had the matter, you have to pass an order. Directly to produce the certified copy. My what order is challenging.
You have produced the certified copies of what?
But happen, Malad, kindly.
You have got the certified copies. All right,
what?
come on the next date.
Lord, my lord, I was keeping it on, Lord, Tuesday at 4 p.m. Tuesday at 4 p.m.
Will remain in the list.
Lord, difficulty is tomorrow, if it is taken up on Friday, he has difficulty. Monday, I will have problems. Keeps it on Tuesday, Lord.
You have difficulty. Friday, he has difficulty.
Keeps it on
Tuesday, I will have difficulty.
But the difficulty is, Lord, the daughter has qualified exam. Lord,
yes, Mr. Mukherjee, after all,
Lord, it is his daughter.
Why would not
he earns 1 crore 70 lakhs yearly?
But why?
Education expenses.
This is 1 crore 70 lakhs.
Please consider that.
When your lordship is there,
The date when your lordship will leave. Lordship convenience happening next Monday. Next week at a din now.
I think these fixed matters from next week, I have to take it up from 10:30. I think that's better.
I'm not
We're agreeing.
But also I'm agreeing anything, my lord,
I can take it up. Motion, no motion.
this is of some importance.
That is right.
Education of the child is of some importance.
The Chakraborty, all matters.
Vice President of
Chakraborty, now you are receiving that 1 lakh.
3 lakhs per month expenses. I have explained. I am carrying documents. Labatina class 12. Daughter's expenses. Lakhs. But one thing.
11th.
Not only one thing. Just for your lordship's kind concept, the court has directed payment from the date of order. The law is from the date of application. The date of